Hi, I'm Karen Hussey. This is Steve Williams, and this is Bobby Truey. So we're KBS, the way we're sitting here, which is probably pretty accurate. We are delighted to have you guys participating in the first of our 2018-19 school year webinars. This topic today is one that a lot of people want to pretend doesn't exist until they get the grumpy email from some publishing company, and then they call us and say, we should really have more training on copyright law. And so our purpose here today is to give you guys the tools that you need to actually function in schools without violating the copyright laws. So let me just let you know what the plan for today is, and then we'll get rolling. First, we're going to cover the basics. I'm hoping that we move pretty quickly through this. I think the first little bit of the show is going to sound like just us telling you the law, but just trust us, we're going to get to good application, but we got to start with some of the basics. And then the majority of the time we spend together will be dealing with issues that schools commonly deal with. So I'm going to talk about making photocopies to use in the classroom. We're going to talk about teachers to teachers, selling lesson plans and curriculum and a kind of something like that. We're going to talk about whether or not you can stream Pandora or something like that in the classroom. We're going to talk a little bit about de minimis use, how much is de minimis. Then we're going to talk about movies and TV in the classroom, public performances like your show choir, speech team, that sort of thing. A little bit about using clip art on the internet, and then finally test the student record. So that's the game plan for today. We will be done by noon.
Slides are available on the website. We just had that question come in.
Yeah. Sherry emailed out slides to everyone, but they are also up on the website, which is ksbschoollaw.com. And then if you click on the calendar tab on today's date, it should be the most recent version of the slides.
And all circulars and all their documents we're going to talk about.
Okay, so you're next. Who's next?
All right, so what we're not talking about today is trademarks. So essentially, Nebraska Cornhuskers, Herbie the Husker, the black shirts, that kind of thing. We're not talking about trademarks. We're not talking about service marks. We're not talking about the name of your school or your mascot. That's what we're not talking about.
That is if we still want to own those Nebraska things at this point.
So what are we talking about? From the U.S. Constitution, this shows you how important they thought it was. They put this in the very first article of the United States Constitution, and it says that Congress has the power to promote the progress of science by securing for limited times to authors the exclusive right to their respective writings. So that shows you how important they thought it was, but that's it. That's all the guidance we have in the Constitution. So we have to look elsewhere to find out, fill in the gaps and find out what else this means. So we've had, when we say multiple congressional acts, there's a lot. The first one was in 1790. They've redone the Major Act many times, and then there's been amendments to those many times. But if you're ever bored one night and having trouble sleeping, you can click on that link. It's a 370-page document that discusses way more than you've ever wanted to know about copyright. It provides a lot of detail. It is complex at times. It's frustrating to attorneys at times. They'll give you tests and you think, oh, great, there's a test. This should be easy. It's a 4-part test. You'll find out there are no bright line rules in many of these areas. So just keep that in mind as we go through these. The big act that's really in place these days is the Copyright Act of 1976. But as I said, these things get amended. I counted them up last night. At least as of 2008, this had been amended 69 times. So it's nonstop, and they're always tinkering with some part of it or another. But these contain the rules on how copyright materials are going to be allowed to be used. It protects original expression, as we'll talk about, I think, a little bit. The originality requirement is not super high. It's eligible when creation is fixed in a tangible format. That just means it's put into some format that you put your hands on. The length of the copyright varies. In most cases, it's really based upon when it was created. Although you're not required to register a copy mark or a copyright, it's created as soon as you create it. If you want to sue somebody for it, it does have to be registered at that point. So keep that in mind. Here's a handy dandy little chart that shows you how long a copyright will last. This chart isn't perfect, but what I like is it shows you the trend. You can see how it was relatively short back in 1790. It's grown and grown and grown. The current standard is the author's life plus 70 years. So that's a pretty extensive copyright law. Anything pre-1923, so if it was created before 1923 on today's date, it's in the public domain, and we'll talk a little bit about that. I did want to share with you that there's a good website for public domain music information, and that's pdinfo.com. And it tells you if a piece of music is in the public domain or not. And believe it or not, Wikipedia does a great job on all of this, but especially books, of telling you, and they tell you what's coming up and what already is in the public domain. So the trend, as we said, was longer time periods for copyright protection. You know that fancy little C with a circle around it, you'll see that it stands for copyright. You'll see it on most documents. For works published after 1989, it's not required anymore. So just because you don't see that C or that copyright doesn't mean it's not copyrighted at this time. So just keep that in mind.
And if there is a copyright symbol on it, that clearly means that they care about you not stealing it, but no copyright symbol doesn't mean it's free for the taking, which is something that sometimes students have told us they thought was the case. So many times we get phone calls. In fact, my daughter is a big hockey fan, so she listens to a hockey podcast, and they were playing Imagine Dragons' Thunder, you know the song Thunder, Thunder. Imagine Dragons is a very aggressive enforcer of their copyrights. So this podcast got a takedown notice about the Thunder. And Anna was like, my daughter said, that's so stupid. Imagine Dragons is being done because they could sell more songs if they let more podcasts play it. And I get that from school administrators too. We should be able to use whatever music for the dance team to do their dancing at halftime, because that would just sell more copies of the music. But remember, copyright is not about money. Copyright is about control. And the best thought experiment for all of you is, if a white supremacist group wanted to use the song Thunder to support their cause, I think everybody would agree that Imagine Dragons should have the right to say, we don't want to be associated with that. So copyright is not about money, it's about control. And the idea that it's so stupid that when we call these music publishers and ask them for permission to use their music, they won't agree. They just don't want to mess sometimes with having schools use their material, because it's about control, not about money. It's also not about giving credit. We do such a good job with kids in the classroom talking about plagiarizing is using somebody's work without citing it. But just because you cite somebody's work doesn't mean you are permitted to use it. Again, the fact that the white supremacist group has Thunder by Imagine Dragons scrolling across the Nazi video while the music plays in the background, that doesn't make Imagine Dragons any happier about the fact that their work is being associated with white supremacists. So just because you give credit doesn't mean it's enough. And just to go up to this slide here, you'll notice that this is not our original work. We took it from Tom Bell, although he has used a Creative Commons license to say that people can use it. But it's not enough for us to give Tom Bell credit. He has to have allowed other people to use it, and that's what he did with his Creative Commons attribution. It's also really not about criminal law. I have a school superintendent that calls me all the time, and she says, well, I want to talk to you before I go to Leavenworth. We aren't sending anybody to jail for violating copyright law. It's all about money. But the fact that schools basically have unlimited money because you have levy authority actually makes schools a more inviting target for copyright enforcement, not a less inviting target. Now, there are some groups that give special privileges to users, especially for educational users, and PBS is a great example where they basically have said in their all of their copyright material that they will let any educational group use their stuff as long as it's not inconsistent with an educational purpose. But just because you're an educational group doesn't mean everybody loves you as much as PBS loves you. So the idea that I'm a school, I can use this stuff for free because I'm not making money off of it, that is absolutely not the case, even though a lot of people kind of want that to be the case if they're in education. That's not how the law actually works. So copyright protects the creator of a creative work, and it doesn't take very much creativity to make it a quote-unquote creative work. We'll show you an example here in a minute of a picture of a basketball that doesn't look very creative to us, but it does have copyright protection. It does not include facts, so like the temperature at which water boils, that's not a copyrightable thing. It does not include ideas, but it might include the unique expression of ideas. And actually the most interesting case law in copyright right now, there is a whole body of case law involving animal selfies. This is a monkey that a wildlife photographer had just left a camera sitting out in the wild, like to take a time-lapse photograph. And this monkey figured out how to take a picture with the camera and took this image. The owner of the camera copyrighted this image, and then PETA sued the owner of the camera, saying that he was committing an act of animal abuse by stealing the animal's intellectual property. Believe it or not, there is also a bunch of litigation about elephant painting. Like if you put a paintbrush in an elephant's trunk and give it paint, there are elephants that like will, you know, make paintings. PETA has also sued to copyright those as works of art owned by the elephant. And the United States Court of Appeals for the Ninth Circuit dismissed a lawsuit involving this monkey picture. The lower court said animals cannot own intellectual property because there's no creativity no creativity used by the animal because they can't have creativity. And Laura, we got this picture. If you Google animal selfie, this will come up. It's actually on a Wikipedia page. And I can use this without permission because the animal does not have a copyright in it. And the photographer does not have a copyright in it because the photographer didn't create it. And the animal does not have the cognitive ability to be creative. And so animal selfies currently do not have any copyright. There we go.
Okay. So we talked about all this. Yeah, any use is either in search of a license or an exception. So anyone who violates the exclusive rights is an infringer, and therefore that person can take a certain number of actions to get you to stop. And so we get the question all the time, but we're a school, and this is straight again from the definitions talking about the term anyone really does mean anybody, including somebody who's an officer and employee of an instrumentality of the state. And so in Nebraska, that could be a political subdivision, which is a school. So any of the school's employees, any board member, anybody else could either be liable individually or could subject the district to potential liability. So to establish a copyright infringement, it's pretty easy. And when we walk through the cases here, it's going to be easier to tell because you're only fighting about one of two things. Number one, the person who's trying to get me to stop using it or trying to get damages from me doesn't actually own it. We'll talk about cases where teachers, for example, have been involved in copyright lawsuits where they're trying to enforce rights that they don't have because it was actually their school district all along that owned the copyright. So we oftentimes fight about, number one, the ownership side of things. But then if we assume ownership is met, and again, in some cases it's easy. In some cases they concede that ownership is met. Then we move on to number two. Is the copying, is the use of that work somehow unlawful? They reproduced it when they shouldn't. They didn't, they exceeded what was allowed by the license. So there's really only two fighting points in each of these cases. And as Steve mentioned, they get much more complicated in each of those subpoints, but for the most part, that's it. So we're just going to put this list up here. We're going to talk about several of these as we move through. But we've actually had a lot of cases here in Nebraska. I know over the years there have been copyright presentations at statewide conferences where we've put up examples that we've had, but whether it's poetry, pictures, songs, warm-up music at basketball games, any of that stuff is subject to the copyright holder or the person enforcing that person's rights telling you to knock it off. And so a lot of these, like I said, we've got examples coming up as we move through the materials here.
So this is an example of a copyright infringement takedown notice that we received just this school year. And the school district was nice enough to say, hey, you can share this. Thank you. This is certainly not the only example of a school district getting a takedown notice. But if you look at that under where it says catalog image 881-98224, that's the picture that they've copyrighted. Now this goes back to the idea that this doesn't really take a lot of creativity. It's a picture of a basketball and a flippin' net. And so, you know, notice that we don't have interpretive dancers going around the rim or it's a different color. This is a standard, just a photograph of a basketball and a basketball net. But that level of creativity is enough for that to be copyrighted. And so then what these companies do is they have bots that go through and check your website And this school had it down under their basketball team sub page on their website. Somebody had it's the first image that comes up when you Google basketball. And they just right-clicked, copied, and then pasted it onto their school district website. And so this is the proof, this is the document that you get from the copyright holder saying, here's our image, here's proof that this was on your school district website, here's a screenshot, and here's the URL that proves that it was, that we went and found it on your space. We've gotten this with, like Bobby said, a little poem that somebody put in the school newsletter. We've gotten a lot of clip art ones, and it seems to be basketball. That's the ones that most often are, but we've had all kinds of like the letters thank yous, the words thank you spilled out with like Scrabble tiles. That was one. And so it doesn't have to be super creative. And notice that this picture doesn't have the little C in a circle on it on the original image because it was taken after 1989. They don't have to have that copyright image on it to warn you not to copy it. Was this me? Yeah. If a school does get a takedown notice, I don't want you to feel like you're the only one or how could you be so stupid. Texas, Missouri, Georgia, USF all had their Twitter accounts suspended because they were playing, they had pictures of their student athletes with music behind it, but they had not asked for permission to use the music before they put the little videos together. And of course, the athletic departments thought, well, we're schools and these are our own pictures and it's just a little clip, so it's not the entire song. And none of those were defenses to having to take this down.
I think what makes this interesting too is if you notice the date for those college football recruiting junkies, this was National Signing Day. So a lot of the videos and images that were posted were these people on the internet that make edits for kids announcing their commitments to a school or announcing their official signing. So in some of these cases, the Texas, for example, Texas football account retweeted a post that the student athlete, the 17 or 18-year-old himself had posted. So it's like the kid, right, was the first one to create the copyright violation because they took some song that one of Sony's protected artists has copyright interests in. They posted it, the kid posted it to his own site, and then the university that was recruiting that kid retweeted it. And so they're not gonna go after the kid, right? They're gonna go after the institution. So Sony sent all of their takedown notices to the schools, even though there was no upline administrator that ever authorized it. It was some media specialist. It was Anna's daughter in the Texas recruiting department that retweeted these kids that had posted the videos. So to me, that shows how far you can drill down in the concept that, yeah, they're obviously going to go after the school.
Because that's where the money is. Yeah, exactly. That brings us to fair use. That's still me.
Yeah.
So this lens case, you guys have probably heard about this. This is the lady that took the video of her very young kid, like 3-year-old kid, dancing to Prince's song, Let's Go Crazy. And Universal Music aggressively enforces all of its copyright in favor of Prince, the estate of Prince now, but at the time Prince was still living. And so they had a bot that went through, and every time any piece of Prince's music was played on the internet, they would send a takedown notice. So they didn't even watch the video. They didn't do any kind of analysis to see whether this was okay or not. They just automatically sent the mom a takedown notice. And the court in this case, ultimately the family lost. They had to take the video down. But the court said in order to enforce your copyright, people like Sony and Universal, you have to do some groundwork. You have to look at it and make sure that the person using it is not under the fair use doctrine, which we'll explain here in just a second. But so what was interesting about this case when it came down, we really thought it would slow down the number of takedown notices that we were getting because the people that are demanding that you take it down have to do some legwork first. But it really hasn't slowed down the number of takedown notices. And as you'll see here, this example that we have, they've done their due diligence, right? They've said, look, this doesn't appear to be fair use. It appears to be you advertising your basketball team. This is what the copyright holder now has to do to prove to you that they've done some spade work to make sure it's not under the fair use doctrine. So what happens if we get caught? This is the scary part. The basic level of damages is between $750,000 and $30,000 per work. There are some really frightening cases involving colleges where kids have used the university's network and computers and technology infrastructure to illegally download music. And schools were tagged at $750 per song. So if a kid has downloaded 5,000 songs using the school-owned computer or school-owned internet access, you can see how that adds up pretty quickly. If it's willful, we had a teacher who just used the school's computer and technology infrastructure to download all the Game of Thrones seasons to date. And they were alleging a willful infringement. Now, we were able to resolve that on the school's behalf, but that's 150 grand per work. So, I mean, now we're talking serious money. And if you can show that you weren't aware and had no reason to believe you were infringing copyright, that's not a get out of jail free card. You can see that you can have the damages reduced to $200 per work, and $200 once is no big deal. But if a kid has downloaded 5,000 songs, $200 per work turns into, again, pretty serious money. For the most part, when we get a takedown notice, we contact the copyright enforcement agency. We usually plead poverty and it's a school and whatever. But I don't think we've gotten anybody off scot-free. Most of the time we are just able to talk them down to less money. But I don't think, maybe once we were able to get them to go to zero, but that's not typically we just talk them down and we pay less than they originally demanded.
The only time I can remember we had one, somebody put up a picture of Rob Gronkowski from the New England Patriots. And I thought, there's no way they're going to let us get away with this. And it was actually ESU1 contacted them directly and said, hey, we're just a poor little school and leave us alone. And they go, oh, you're a school. Okay, that's fine. And so they actually did let them get by. That's the only one I've dealt with where they got away with it.
But if you do get a takedown notice and a demand for damages, it's worth the money that you spend having one of us or even your administrator call, because most of the time we can talk them down pretty substantially. And I think half is what we've always shot for.
Yeah. And the tough part is, like in the case Karen was talking about, the University of Nebraska kids downloading music, the university turned and pointed the finger at the kids. They're like, look, we had no idea this was happening. They're using software to clearly and intentionally violate people's copyright. That's tougher for you as a school. And there's going to be some boards who say, you know what, we'll stand in protection of those kids. So I think that's what you need to be thinking through too. To the extent this is a board issue, I think you're asking questions about settling claims where in some cases you may be able to point the finger at kids or staff members who have done the wrong thing. And so we'll talk about liability theories, but a lot of universities will just point at these students who are themselves adults. A lot of K-12 schools wrestle with, should we show up and pony up money to answer for the unlawful actions of our employees and students, even if we could otherwise, show that they knew what they were doing. So. And
the problem in the Eighth Circuit with pointing the finger at somebody else is there's a horrible case from the University of Minnesota where the University of Minnesota went all the way up to the Eighth Circuit and said, look, it's not our fault, it's these rotten kids. And the university got clipped. I think the award was over $1 million and they settled it. So I don't know what they ultimately paid out. But saying the kids did it, I don't think in a K-12 context is going to defend us.
All right, so what happens at the school-based level? We updated our policy recently hopefully to increase compliance and to preserve some technical defenses that we might have. And so if you're a policy subscriber, you had this past summer. If you're not, you might want to take a look at your copyright policy and just make sure that you're up to date and have some defenses in there. But we've highlighted the provision that I think we want to emphasize, and that's a staff member who wishes to use any non-original work must obtain the prior written permission of the building principal. So we're putting in a safeguard there that makes sure that hopefully our principal has a little bit more knowledge about the copyright law. And unless you've obtained a license or for its intended educational purpose, no principal shall grant permission for requested use of a copyrighted work unless he or she has reasonable grounds to believe that it is a fair use under applicable copyright law. So you can see the principal is going to be expected to have some level of knowledge about fair use. And so that's going to take some studying on his or her part because it's not as clear cut as we'd like sometimes. The distribution of copyright compliance materials. We do have to make certain information available to those individuals, to staff and students, so that we do have defenses available. We do also provide that material with our service. Is there something you want to add on that?
Just that what we're doing here and having two layers, the teacher and then the principal have to analyze it, is that helps your argument that it was not any intentional violation. somebody there being able to articulate that they at least thought through it, even if they got it
Even if you
completely
get it wrong, that's right.
Did you think through whether this was a violation? Did you think you had fair use? Make some notes about that. Easy breezy. I mean, it doesn't necessarily mean you're not going to get tagged with some violation, but it gives us something to send back to the copyright company saying, look, we're going to get your damages half down even if you were successful.
Yeah, you just have to have a reasonable belief that it wasn't fair use.
Right.
So, and what can happen? Well, if you're a student, you could be expelled, and if you're an employee, you could be terminated. So, I mean, it's a pretty serious issue, especially if it's one of those $30,000 violations or $150,000 violations. You're much more likely to get tagged by the school for that kind of incident.
Okay, we're going to hit some common.
For the record, we have paid the appropriate licensing fee for any image that appears in this slide deck. Randy Glassbergen is one of the cartoonists that we have a subscription to. Annually, we pay him, I don't know what, and then we can use all this stuff. So I just want you to know that we're modeling appropriate use of intellectual property.
Okay, so the first thing we're going to talk about is making copies. This is sort of the analog version of copyright violations. And it's still one that we get from time to time. For the most part, these are obviously a lot more difficult for a copyright holder to prove a violation, right? Because if you have consumable textbooks still, and that copyright holder has no idea really that you've made an extra copy for the kid who just optioned in before you were able to buy a copy from the company, it's hard for them to detect it. But nonetheless, this is really the basis of the copyright law. As you continue to digitize things like your textbooks, your workbooks, it's going to become easier to detect these things. So knowing when you can make copies for educational purposes is important. So this is the first in a series of hypos that we have. They're not all structured the same way, but what we're trying to do is hopefully highlight some of the most common questions that we get. So let's assume we have an English teacher who finds an article from the New York Times talking about the use of the Oxford comma.
And of course, it would be about how you should not use the Oxford comma, because that's the only American way.
You can see why we use this hypo. And so what they want to do is it's an English teacher who says, you know what, here's some good arguments for why you should and shouldn't use it. Karen's obviously wrong. Let's distribute this article to the class and sort of get their input. So she makes an article or a copy of the article. She prints it off from her desktop, makes a copy for everybody else in the class. Has she violated copyright law? So to really get into this, you have to talk about individual liability theories. The interesting part of how this works is there is an initial assumption that the person, not the entity for whom they work, is the violator, right? Because you could have an intentional violation. Now, as Karen pointed out, for the most part, they're going to come back at the school even if they find a violation like this.
But the reason this information is important for you is when you take this back to your staff, you need to explain to them, because teachers will freak out when they hear this, that they can be liable personally for the full damages.
Right. Yeah, absolutely. And that's the initial presumption in the copyright law, is that each individual is tasked with understanding. So there are individual defenses. Courts can suspend statutory damages or reduce them where the infringer had a reasonable grounds to believe that his or her use was a fair use, and that infringer was an employee or agent of a nonprofit education institution. This is one of several examples within the copyright laws where they actually talk about the significance of being a school employee. That's why we can't emphasize enough that we may not be able to tell you how exactly you should play background or warm-up music at your basketball games during this presentation, but we can tell you how you can avoid most of this, and that's having some system in place to do some amount of analysis so that you can always say, we had reasonable grounds to believe our use was either a fair use or in some other way not a violation. So the school liability theories. The first and the easiest one is contributory infringement. This is based on you saying to somebody, teacher walks in and says to principal, hey, new kid in my class, what am I supposed to do about being short a textbook or a workbook? Principal says, why don't you just run off copies until we can get one ordered? Unless that is authorized by your license from the textbook company, you have violated copyright. The contributory aspect of it is because you've had a principal, somebody who is able to direct or demand something be done, asks a staff member to violate copyright law. The school's not going to be able to get outside of that saying, well, the teacher should have known that the principal was wrong, because you as the school may have a contributory infringement violation because you encouraged somebody to do that. The key emphasis, though, is looking for the financial benefit. So in other words, if the idea is that, hey, I'm cheap. My superintendent is cheap. I don't want to pay for another 2 copyright protected workbooks. So instead, just make copies. That's the financial benefit. There's a financial benefit to not paying for licenses for cartoons. So, hey, teacher, put together an in-service training for the rest of the staff and steal some of those really funny cartoons off the internet. You have decided, you've directed that person not to buy them. You said the school isn't going to pay for them. So in that case, you've received a financial benefit simply by not purchasing the license. But it requires some element of knowledge of the infringing activity.
Okay, so this Bosch case is kind of an interesting case. It's actually a case involving a medical school, not a K-12 school, but this Bosch got into hot water with her department chair. And basically he changed the locks on her office and said, forget you, we're not gonna let you teach this class that you wanna teach anymore. And so he changed the locks on her office, but then he had Ball Kell, who's the professor that's gonna take her place, go into her office, get her teaching stuff off of her computer, and then just get ready to roll to teach the class that they're not gonna let her teach anymore. Notice 2 things about this to begin with. One, the defendant is the individual, not the institution. So it's a good way to scare your staff, to remind them that they can be individually liable for what they steal. The problem was that the material that this teacher had put together for her course, she had done before she came to work for the university, and she had actually filed a copyright application with the Copyright Office to copyright her unique approach to teaching this part of medical school. So she files an infringement violation against the individual, but she doesn't really want money damages against the individual. She wants them against the institution. So the question is, can the college be liable for this Ball Kell going in and taking the stuff that Bosch owned? The school moved for summary judgment, said to the judge, hey, we should not get tagged for this, and the court denied it. It said, look, school, you were aware that your employee went in and took this teacher's teaching materials. You should have been aware that she'd copyrighted them, that you didn't own them. You authorized the photocopying of somebody else's stuff that they owned. You were aware that they were going to use it for your benefit, and you didn't do anything to stop her from using this other person's teaching materials. Now, 99 times out of 100, the curricular materials that your staff are using are owned by the school district. So I'm not worried about using somebody else's lesson plans. But if somebody has put together a great unit and then you photocopy that and use it for other people, you need to make sure that the stuff within that unit is also not copyright protected. Because then you can be held that you were contributorily infringing because you encouraged your teacher to steal stuff and use it. So that's contributory infringement. Does this one need to stop?
Nope, keep going.
You can also be vicariously liable if the other person has to prove, the plaintiff has to prove that it was direct infringement. You don't have to prove that you knew that the other person was responsible. And they can also impose liability on you if you get any financial benefit or if you have supervisory control. Again, what this slide is really meant to tell you is you need to train your staff on copyright, because you can get tagged as a school district for liability for your employees' violations, even if the employee is also sued as an individual. And it could be, you could not even know. The basketball picture, the school district didn't even know that somebody had put that on their website. It doesn't matter. The school district was vicariously liable because they should have kept track of what their employees and students were doing. Is this me? Yeah. Oh, yeah. So this is a student group that was showing an old film every year. And you can see the date of this case was 1972. And the film itself, I think, was made in the 1950s. And so the student union showed it every year. And they got a takedown notice every year. The student union thought they had a license. The question is the university responsible if they knew or should have known that this student group was having a fight with the holder of the copyright from the film? Every time they showed it, the student group said to the university, hey, remember, we're having this fight with the person that owns the rights to the movie. We think we have a license. In this case, the school won because the court said that although the university had the ability to control the use, They could not be held responsible for everything that the student group did, and the student group had given them notice that they had a reason to believe they had permission to use it. In this case, the university got off the hook. So here's what this tells you. If the PTO is having movie night, you can't just ignore the fact that there's potential copyright significance to that. You need to ask them, hey guys, do you have your act together? Do you have a license? Then if the PTO says yes, you're covered because you've made a reasonable inquiry and you had a reason to believe that they were doing it the right way. And in this case, the reason the university was not held liable is because they had had those conversations. Even if you're wrong, even if the PTO lies to you, you now have an excuse to not be liable for their copyright violation. So the point of this is that you have to ask questions.
All right. Well, we're up to.
So while we get oriented, I do have a quick question on text. If a district purchased the public performance rights to a movie or song, do those rights apply if the PTA shows or plays that work at the school building? Nope. You are two separate legal entities. Now, you as a school can include the PTA or PTO in what your request is, but if your license is just for the school, that will not automatically cover your PTA. They are going to need their own public performance license. We're going to show you the place to go to, a way to get the license. I've done this for my own PTOs, and it's like $50. It's not terribly expensive.
All right, fair use is the monster defense, the monster exception that exists. And this is one where I talked about a little bit earlier. You get a 4-part test that we'll talk about here in a bit, and you think, well, this can't be too hard. Unfortunately, that's not true. But the number one piece we want you to take away from this is educational use does not equal fair use. And that seems to have been a common misconception of those who violate this law. But the fair use concept comes out because, as we said, we want people to have control over the content they create, but we don't want to have a blanket prohibition that prevents others from using at least some part of their work, because we want some of that information to be shared freely. It's just better off as a society. That's the decision that's been made. So fair use, it was an exception that was enacted in that 1976 Act and permits you to use copyrighted materials in ways otherwise that would have been infringing on the creator's rights. It is an affirmative defense, which essentially means if somebody comes after you, you have to raise it as a defense. And the burden of proof would be on you to prove that it was, in fact, a fair use. So the most common examples are criticism, comment, news reporting, teaching, that's our big one, scholarship, research, and parody. That's where you get all those Saturday Night Live presentations that would seem to be a copyright violation. That's how they get away with it. So the reason this is kind of frustrating is you'll call to ask if this is a fair use, and our response is going to be, it depends. And the quote here kind of sums it up. Although the courts have considered and ruled upon the fair use doctrine over and over again, no real definition of the concept has ever emerged. So after all these years and all these cases, since 1790, we still don't have a real definition, a bright line rule for fair use. And since the doctrine is an equitable rule of reason, no generally applicable definition is possible. So they're saying they're never going to come up with one, is basically what they're telling us there. This comes from an attorney that represents the music industry. Fair use is the teachers and the performers and the lawyers' nightmare because there are no clear answers to almost anything. So it's kind of like pornography. You know it when you see it, one of those cases. And so Bobby will tell you all about those. So here's your 4-factor test. The purpose and character of use, including the nonprofit educational purposes. So obviously we have a leg up on everybody else because of that provision. The nature of the copyrighted work, the effect of the use on the potential market for the value of the work. That often works in our favor as well because, again, we're a nonprofit educational institution. We're not typically going to have a huge impact on the value of the work. And then the amount and substantiability of the portion used. So how much are we taking? That's going to be a huge part in many of these cases. All right, so here we have, what's this? This is Ms. Hazy.
Yeah, this is, the Act does not tell us how much copying exactly we can do for teaching purposes. Back in the day, when I was teaching the school law course for UNO, I 100% violated Copyright Act because I would just take chapters out of the book I liked and then put it together in a big packet. We know that you cannot use photocopying in a way that undermines the market for the product, but it doesn't tell us exactly how much is too much, and that's it's difficult. There are guidelines on classroom copying for not-for-profit groups that are in the some of the material that we've included in the circular and on the website, and we'll buzz through some of these specific examples. So you can make a single copy by a teacher if it is for use in teaching in preparation for a class. You can do a chapter from a book, an article from a periodical, a short story or short poem, or a chart, graph, or diagram. But you can't replace a book by just copying chapters from a bunch of different books, if you see what I'm saying. You can use multiple copies, one per kid in the classroom. If it is for classroom discussion, and if it's brief and spontaneous, if it doesn't meet the cumulative effect test, and each copy includes a notice of copyright. So this slide right here takes us back to the hypothetical that we're talking about, the teacher that makes the photocopy of the New York Times article. So this is a chance for me to check for understanding. Just in your brain, think, how would this slide answer the hypothetical we've given, and then we'll give you the right answer at the end.
And real quickly, the slides after Steve went through the fair use test, the 4-part fair use test, when you call us, that's what we're going to apply. The last couple of slides, and this slide in particular, talking about brevity, spontaneity, that's part of this circular document that we've attached, where essentially you had various groups from the industry come together when they updated this in the 70s and asked, okay, we got to provide some guidance to classroom teachers and librarians of how to do this. Otherwise, they're going to sit in their classroom and try to figure it out. So when Karen's going through the single and multiple copying, that comes straight from that Circular 21 document. So this is law to the extent that it's guidance from Congress, but understand when we talk about these next few parts, they are part of analyzing whether you get to use the circular's protection. They are not necessarily directly implicated by the fair use test itself. So it's kind of confusing, but yeah.
So you see here that we have the copying has to meet the brevity and spontaneity tests. The brevity test literally counts the number of words that you've copied. So if the poem is less than 250 words and it's not on more than 2 pages, you can copy it. If it's a longer poem, you can have an excerpt of not more than 250 words. And literally look at this footnote. They say, oh, yeah, but if you want to finish the last line, you can go over the 250 words to like make the thought complete. For prose, the brevity test says the complete article, if it's less than 2,500 words, that's about 10 pages. About a typewritten page has about 250 words on it, and I know that from being a speech coach.
But how many Oxford comments?
None, because it's well written in America, man. And you can have an excerpt from a prose work of not more than 1,000 words or 10% of the work, whichever is less. And again, you can say you can expand it to finish the unfinished line of the paragraph or thought. You can use one chart, graph, diagram, cartoon per book. As long as you're not taking the entirety of like if the entire point of it is one big illustration, you can't use it. But if it's a book that has a bunch of illustrations, you can use one picture from a book, and that's considered brief. And then spontaneity, the second thing that you have to ask about is it because the teacher just had this great idea, or did the principal tell her to do it? That undercuts the spontaneity. And it has to be close in time, like current events, or this article was in yesterday's paper and I thought it was really interesting. That's what you need to meet the spontaneity test.
Yeah, and you can't, what it says literally in the circular, because remember, this is the 70s, right? They're not thinking about emailing the copyright holder and getting a response back. They're thinking about like snail mailing a letter. Can I use this article? So what the circular says, and what I worry about in terms of the circular, probably my biggest concern, is it only allows you to use these classroom copying suggestions from Congress if it would not be reasonable to expect that you ask the copyright holder for permission.
In time, like there's no time.
Right, like I have to use this article right now. I can't wait 2 weeks for a snail mail to be exchanged. So when you're printing off something from NewYorkTimes.com, I think it's a little bit harder to make the argument. But so anyway, this is still in there. It's not that it's been read out, but I worry about how much easier it is to ask for permission nowadays when you can buy a license from the New York Times in a matter of seconds.
And then the courts will also look, or the circular also looks at what's the cumulative effect, right? If you're copying it for just one course, that probably does not have a cumulative effect. If it's limited to one short poem, article, or story for one class term, or 3 items from the same collective work for 1 class term, then that's not going to have the cumulative effect of, I guess the idea is that you wouldn't buy the whole book just for 1 poem, but if you're going to copy 5 poems, then maybe you would go to the principal or the superintendent and ask them to buy the book. So the cumulative effect can't have the impact of, otherwise I would have bought the book if I couldn't have made these copies. You can have 9 instances of multiple copies for 1 course, and that doesn't apply to your current events classes. You can have more than that for news periodicals if you have a current events section of your class.
All right, the prohibitions, we'll go through these pretty quickly. One, they have a big hang up. As you'll see, it'll be a pattern. They don't want you creating anthologies, compilations, or collective works. There's prohibitions.
Which is what I did, totally, I confess.
Those are in several sections. They don't want you using consumables or copying the consumables, the workbooks, the standardized tests, things of that nature. That's a repeated provision. And they don't want you substituting copying for, obviously, the purchase of books. And so I think Bobby had talked about that earlier. When the science book isn't there, they don't want you to copy the entire book, even if you're going to purchase it later. So, and also when you do make copies, you can't charge students beyond. They don't want you making a profit on any copies that you do.
And I don't think you can charge students anyway, because I think that would be a student fee under the Student Fees Act, in addition to being a copyright violation.
So the answer to our hypo, the English teacher made that copy from the article, yesterday's article from the New York Times about the Oxford comma. Has she violated the copyright law? No. She's met the brevity test. She's met the spontaneity test, assuming, of course, that this was 2,500 words or less, which we probably should have put in there. But assuming it's a normal length article, then no, she wouldn't have violated any of the copyright laws.
I think the only thing I'd be worried about is, number one, is the New York Times going to say you should have bought a subscription for every kid in the class. And you should have asked them for permission. That's that part of the spontaneity test. But I think for the most part now, we would take the position that this is acceptable.
Yeah, I think I think she's cool. I don't think she's violated the copyright law. So this is the first time we had built in a chance for folks to text questions in. We had one person already text in, and I answered that question from ESC3. Anybody else that has a question, you can send a text right now while I tap dance a little bit. Otherwise, since we're a little bit behind due to our technical difficulties, I think we'll keep trucking, and as we get texts, we'll just fold that into the presentation. So next question is whether or not teachers can sell their lesson plans and their curricula and that sort of thing. And this is actually another really interesting area of copyright law, because it's just kind of an emerging area. Now when you do that, you have to click back into the slides, so my click will work. Yep. So here's our hypothetical. Oh, I love this cartoon. I don't know if you can.
Darn it.
Yeah, no, they can read it because
Okay.
they aren't seeing where our box
Okay,
is.
gotcha.
Yeah. So school administrators require a teacher to develop lesson plans, which you all should do. The teacher spends 20 hours of her own time at home developing thorough and intricate plans. As the year goes along, she thinks, wow, Madeline Hunter was right. Good planning leads to good instruction. How amazing. So she thinks that since these lesson plans are so awesome, she's going to make a few dollars by selling them on Teachers Pay Teachers. Question is, can she do that? That's the entire section that we're going to talk about next. And this is, like I say, this is an emerging area of the law that you should be aware of. You may have teachers selling stuff on Teachers Pay Teachers now and not even know it. I love this cartoon. So the answer to this hypothetical question is all driven by the work for hire doctrine. And the work for hire doctrine basically says if you pay someone to prepare intellectual property, that person doesn't own the sweat of their brow, you do, right? Because you, the employer, have paid them to create that work. So this is exactly the language from the United States Code. In the case of a work made for hire, the employer for whom the work was prepared is considered the author for purposes of this title. So if you tell the teacher to create the lesson plans, then the school district owns the lesson plans. Unless the parties have expressly agreed otherwise in a written instrument signed by them, and that's going to be the question, have you given any rights to the teacher in their contract or in the collective bargaining agreement or anything like that? So this is the default. The assumption is everything a teacher prepares while they work for you, you own. Because you specifically told the teacher to create the work, clearly that means that the school district owns. And again, this most often arises in the employer-employee relationship.
We're gonna have 4 cases here in a row. We're gonna burn through them pretty quickly. But as we talked about, the 2 elements for proving copyright violation, the first one is ownership. That's where this works made for hire stuff comes in. So the Roop versus Lincoln College case lays out the factors pretty well. And essentially, there's a 3-part test. Was the work the type the person was employed to perform? Did it occur substantially within the authorized time and space limits of their expected duties? And was it created at least in part by a purpose to serve the master? What happened in this case is Roop was a college teacher asked to essentially develop an entirely new program within one of their colleges for like a tourism, sports entertainment sort of major at this college in Illinois. She went to all this work. She went and got a graduate degree at the insistence of the school. So essentially, it's very similar to saying to that teacher, you need to go get an additional endorsement certification and putting that in the contract. She signed all that. She develops this. They are upset with how essentially she's been performing. And they tell her, okay, we want you to do all of these things. You need to go do some additional coursework. She doesn't do it, says, I quit. Her argument is all that stuff that I developed for the purpose of that new major, I should get to keep because that's mine. The college's argument is you were clearly doing it to the extent that you were engaged in your official duties. And really, the test came down to a series of emails that they had exchanged in which she had been asking questions of her supervisors related to the development of this curriculum. So they said they both had good arguments. She did work outside of her expected duty time on it, but she also asked her employer questions about whether it was good enough. This case is exactly what I think having to submit lesson plans is a good idea, even if it's just occasionally, because it evidences your intent as the school to say that that was part of your expected duty. So in this case, Roop loses. We go to the Pavlica case, opposite result. Pavlica is a science teacher in New York who develops essentially this research-based science curriculum completely on his own in the mid-90s. As a part of that, he did not ask the school, should I create it? He did not ask them anything. And in fact, when the Board of Education was updating its science curriculum, they asked him to come in and pitch the curriculum that he had developed. The board picks his curriculum, ends up paying him for his curriculum, evidencing again that he has actually maintained ownership of it. Where this got sideways is he had some guys that were working for a college that said, hey, you've got a moneymaker here. We'd like to start selling this all over the country and have you go train people. So this college pays this high school science teacher to do that, essentially to peddle his program throughout the United States. They get grant funding, everything's going well, and all of a sudden Pavlica's like, why am I sharing this with you? So he tells them cease and desist. The school in this case actually comes in and says, yeah, actually, we think Pavlica owns this. We believe that we paid him for it. We didn't ask him to develop it. And so because they had established those clear parameters saying that Pavlica, I think this is yours. You did it on your own time. You didn't start using it in school until we approved it as a board. You own it. So the court says this is outside the scope of employment because the time spent on it essentially was outside of his course and scope of his duties. Notice
on the 3rd bullet point when it says he did not attain approval to create the program, and I think the most important part is the last 3 words, and he did not use it in the classroom.
That's right.
I think the whole thing could have been different if like the classroom was his test bed to see if this was good or not, which is typically what we see happening with new stuff that's developed by our school district employees.
Yeah, I think that the Roop case compared to the Pavlica case, what they show is if it's something that's going to be used to complete the duties, absolutely, I think you should argue that it's a work made for hire. We're fairly aggressive when we talk about that stuff. The last case is Shawl. This is a case similar to what Karen talked about earlier. Shawl is a real dirtbag, to be honest with you. In 1990, he is convicted of having an inappropriate sexual relationship with a student, somehow gets only probation and continues teaching at this school. Then in 1999, he develops another inappropriate relationship with a sophomore girl who's been assigned to his homeroom and gets convicted of stalking her. Now, this guy there's no way he's surviving past the 1990 incident nowadays, right? But this guy is still there teaching, fighting to teach another day. By the time the school eventually says, all right, sexual assault, stalking, that's probably enough. They functionally cancel his contract. They have 2 administrators and 4 custodians go in and clean all of his stuff out. His argument is that what they gave him back did not include a lot of materials that he had been preparing to use in his class. And so he's essentially saying, I've got a work made for hire. So he files a lawsuit when those lesson plans and things weren't returned to him. By the way, one of the things they did return to him was he had created during his time at school 2 picture albums of these girls. This is like a super creepy case. So I think this is one where the judge comes down on it pretty hard. But I think the combination of the Root and Pavlica cases leads to this court saying, look, if you're motivated to spend time to prepare materials to fulfill your duties as a teacher, regardless of whether you wanted to sell them on Teachers Pay Teachers or peddle them to another school at some point, if your primary motivation was to have a better class because of them, those are owned by the school. The important part is the very nature of the teacher's duties involves time outside of the classroom. So he makes the arguments that they've not made in those other cases. What about at night when I'm doing things at home? The court acknowledges, because the administrator said that's an expectation. You're an exempt employee. Of course you're going to grade papers and do things like prepare your lesson plans for the next day or the next weeks at night outside of your instructional time. That's an important part that teachers don't understand. Leaving the building doesn't make them any less a teacher if their purpose for what they're doing is to carry out their duties.
And I listen to a lot of educational podcasts. I follow a lot of educational Twitter accounts. And this second bullet point, the third bullet point up here, the nature of teachers' duties involves time outside of class. That idea is completely lost on these podcasts. I have heard people that I respect that are, educational heavy hitters say, if you want to sell what you're developing, make sure that you're doing it at home. That is not the test. The test is it part of your duties as a teacher? Then I don't care if it's 3 a.m. and you're, in your car using a privately owned laptop. If you use it the next morning in class, it's very likely a work for hire. That's just I just hear that a ton. Well, do it mostly on your own time and then you'll own it. That's just not true.
Yeah. If you were all sitting here and we said, show of hands if you think you've had teachers sell lesson plans or buy lesson plans on Teachers Pay Teachers, I bet all of you and administrators would probably, I bet that has happened. And if you asked your staff, definitely it would have. Ask and think to yourself, how many times did they get a written agreement from the Board of Education to sell that on Teachers Pay Teachers?
Because
and you got your answer.
They're selling school property. They're
right.
selling like extra textbooks online to make money on the side. That's what functionally they're doing.
All right, we've got one last case on the work for hire. This is a 2017 case out of Illinois. What we had here is a plaintiff was the computer lab assistant for 12 years, and on her own, in 2005, she develops her own program. They didn't do a very good job of explaining what the program was, but it seemed to measure the tendencies of some things that occurred in her classroom. So she had developed it 2 years earlier before she started using it in the classroom. The school had no idea she was using this. In 2008, they figured out she's doing it, and they said, hey, can you rewrite that and give us regular updates on that program? And they incorporated some attendance provisions and things like that. So they used it for about 7 years without any issues. In 2015, they told her, we're not going to use your program anymore. We're going to buy a more sophisticated commercial program. Well, the plaintiff asked for a copy of it, took a look, she says, well, this is just a reverse engineered version of what I was providing to you. And so she quits and sues them for copyright infringement, and the school filed a motion to dismiss. The school argued it was a work for hire, and they owned it. The plaintiff says it couldn't be a work for hire because I created this at home, and the school wasn't even aware of it for 2 years when I was using it. The school's response, and I think rightly so and smartly so, was, okay, forget about the 2005 version. That 2008 version, we did take control, and we did direct her how to complete that program and to give us updates. And so the court said the 2008 version was a derivative work, but they said, is it a work for hire? They looked at different factors. The plaintiff said, hey, I had close control over actual updating of the program, even following that 2008 rewrite. And it could have been written off school grounds, favoring the school. It was a 12-year employee. She wasn't paid anything extra for that program. She was getting all the benefits that an employee would get. And the district in their contract had an authority to assign additional duties, which would obviously include rewriting and updating that program. Court found in favor of the school. They said they didn't talk about the 2005 piece, and I think the school probably would have lost that. But the 2008 program, they said, is a derivative work. It's owned by the school, and they have the copyright, at least partially.
Okay, so if we go back to the statute, I told you that the assumption is going to be that the school owns anything that the teacher puts together, unless, and you see the highlighted language here, unless the parties have agreed in a written contract that we're going to share rights or we're going to do something differently with the ownership rights. And so we want to circle back to this because the question now is, what does the written instrument say? For the most part, we don't think that your standard teacher contract includes the right for teachers to sell or share lesson plans on the websites, again, because you own them. especially when we use professional learning communities and workshop days and curriculum committees to like underlie all of the work that teachers are doing. This is obviously a humongous investment of public resources in the quality of these plans. So having teachers just sell them, they're giving away school property, and I just don't think that is consistent with the law. It's certainly not consistent with the idea that you cannot give away publicly owned things without the permission of the board. So this is the common wording that's in most teacher contracts, something like this, that the teacher agrees to devote his or her full time during days of school to the position in all respects and to perform all of their assigned duties diligently and faithfully to the best of their ability. That's probably enough to cover everything educational at all that the teacher does. And then obviously we can enhance that or detract from that by a school policy or by a different specific kind of contract. Some superintendent's contracts include wording that the superintendent can do speaking and writing on the side. That is going to then change the analysis a little bit. It's going to be what's on the side and what's part of the contract.
And whether it says with approval of the board or not, you can see now that's of legal significance based on the materials.
Because if the board hasn't given approval, then the assumption is that the board owns it. And if the board has given approval, then we're going to have to get into the weeds about who owns what people are doing on the side.
This is our policy.
So this is our specific policy that limits the ability of staff members to give away the stuff that we own. It says that works created by district employees are owned by the district. I think that's fair. I don't think it's being a jerk to have a policy like this. I think it's fair to tell people, hey, we own this stuff. We can enter into a written agreement with a staff member allowing them to share ownership. So if somebody comes to you and says, hey, I've got this great idea, it's really smart to do some kind of little written agreement that says, okay, we'll own it 50-50. And that's not you screwing the teacher, that's actually you protecting the teacher, because otherwise the teacher gets nothing. So doing an agreement, sometimes I think we feel like we're being greedy gimmies, but what we're doing is protecting the teacher. Then the board will only enter into the agreement if it's something that we should have to pay for. It's separate and apart from what we require everybody else to do. Then this last paragraph is something that I put into the policy years ago when we started doing distance learning courses across the state. I wanted to make sure that nobody could claim that if you are in Ogallala and you're receiving chemistry from an Omaha school, that there can be no argument that that's a copyright violation because we're sharing it for an educational purpose. So we have in our form policy, or had in our form policy for years, that the board would grant other educational institutions a non-exclusive license to use their stuff, which again would cover Ogallala streaming chemistry if it had been scheduled through Renovo or ESUC or whatever. And so I thought this was in everybody's policy book. I have discovered recently that although I think it's brilliant, not everybody was smart enough to do what we said. And so this was the beginning, and now we're going to have Beth come in and talk about the next movement about this, what's a work for hire, because we want to be able to share stuff on the OER Commons. So I'm going to pop out.
Yep, this is just the stuff that we already talked about.
Yeah, if the contract's silent, assume it's ours. Yeah, I don't think that's vital. Okay, so I'm going to swap out.
Yep, Beth's going to come while we're doing that. Basically, what we concluded after looking at policies across the state and at various ESUs is that not everybody had a uniform policy or even close to uniform with respect to the ability to share and exchange and collaborate on curricular materials or other education-related materials throughout the state. We'd always had that in our policy, but I think because of this work made for hire concept, it was important to us that if we're going to use something like the OER Commons, which Beth will describe here in a second, that we had something for boards to consider which highlighted what it is that they're actually doing with respect to these legal rights. So it's a small portion relative to what I think Creative Commons and OER Commons could be, which is awesome. But I think it's important for boards, at least because of the requirement that they have a written authorization to share things like a lesson plan for a staff member, that we designated. So I'll just turn it over to Beth at this point, and she can kind of take you through a little bit of this, maybe the bottom part in particular about the
Right. So, and kind of to give a little background of how this all started, the Department of Education is really looking at the standards that they're producing or that they're sharing and developing, and then what resources or what lessons or what units are created high quality units that are created to match then our Nebraska standards, and how can we share those high quality resources or curriculum across the state with all of our classroom teachers without having to worry about work for hire. So the OER process then that's how it was not created, but considered as an initiative that the ESU organization was involved or partnered with our Department of Ed. So through all that, then we had a conversation with KSB Law to say, most of these copyright policies are really not allowing for our teachers to host or post any of their works to be collaborated on or to be shared through OER Commons. So what can we do about that? So therefore, this is an example of a type of policy that could be adopted. And what Bobby is sharing at the end, you'll see that Creative Commons has, 6 types of licensing. And those are the ones that are probably what we want to do in terms of anything that we create, and we are allowing our teachers to post in this type of platform, that it is both non-commercial and share alike. We're also maybe suggesting in some cases that are developed by our Department of Ed that are no derivatives can be made. So what non-commercial, obviously I think all of you are okay with that. The share alike simply means that if I take something that Bobby has created for my class and he has licensed it under Creative Commons with share alike, then I have to also include him as a creator of that resource. I can make, if he just says that it could be non-commercial and share alike, I can make derivatives of that resource, but I have to continue to share it or license it in the same original way that Bobby had licensed that particular work using Creative Commons. Now, again, as we said, for the derivatives piece, maybe your district is working on some curriculum and you want to share it, but you want to make sure that is done with fidelity, and so therefore no derivatives can be made, or it would not be the license that you're posting on there. So that's pretty much how that all works in terms of how we want to share it. And so this particular policy, in my opinion, kind of reverses the process that Karen was speaking about before, right, saying that if I wanted to share something or go out, I would have to have approval from my district. This really says that your district or you as administrators are saying, all right, teachers, we know that you're doing this work under our work for hire policy, but if you are going to share this in an OER format, then this is the licensing that we would request that you share it, and you do not have to have approval from us.
Yeah, the way that I envision it is teacher creates a brand new organic lesson plan based on part of your curriculum. This policy says to that teacher, we as the board have made the decision that participating in OER Commons is a good thing, that we want to not only share the benefits with other schools of our teachers' awesome work, but maybe we can receive that benefit back in another area where a teacher doesn't have a lesson plan, or we want some other type of material. What this would allow your administrators to do is to allow all teachers to share these things to the Creative Commons with restrictions that Beth was talking about, that somebody can't then take it and sell it, which is the opposite of what happens on Teachers Pay Teachers. The school is saying, we'll allow this to become part of this greater commons in Nebraska, which is, eventually hopefully aligned to NDE standards. So the non-commercial share alike is the board saying, send this lesson plan out there to the world, and maybe somebody will make an even better tweak to it, and now we can get that back, giving attribution down the chain the whole way. Then the attribution non-commercial, no derivative part would be, we have this awesome thing, NDE has said, that's great, that's aligned to standards. Now maybe we don't want people to change it because the act of saying it's aligned to standards might be of significance to your board in setting the curriculum. So it allows both of those two things to happen while not, giving away the farm, so to speak, in terms of the rights and care of the stuff.
So, all right. So what we have been working on then as, again, a partnership between the Department of Education and ESUCC is what I'm calling a platform, and it's called OER Commons. And you can find this oercommons.org, and we did a lot of research on, so what types of places can we do this sharing? Where can we go to provide opportunities for our classroom teachers as well as students to access these resources and to build these resources together? So we were talking with other states and what were they using, and OER Commons really popped up as meeting all of our needs. For a number of reasons. Obviously, you see here, low cost was one of them, easily accessible, and the timely thing, the timely piece, in my opinion, is so critical because we can now go in and edit and change those resources on the spot. So if we made some kind of standard change, just a little tweaking in a standard, we can now also adapt or make changes to our resources in OER Commons. And if we're all looking at the same resources, it'll make a statewide change. But what we see is that, you know, when you think about Pinterest or Teachers Pay Teachers or other types of repositories, they may not be aligned to our Nebraska standards. They may not be vetted by our classroom teachers. And so we feel that they may not be the best quality of resources that you can use. And this is where the Department of Ed is really coming in and doing work with our classroom teachers and curriculum groups to do that type of thing. And so within and Nebraska has what's called a hub within the OER Commons. And again, here is the OER Commons look, and this is what you would see if you were to go to that website, but this is Nebraska's hub. So this is where we have financially, put in some dollars to create this hub for our Nebraska teachers to vet and to align our curriculum or our resources to those high quality standards. And so I've given you how to get to our hub. You see it's oercommons.org, and then you have to put /hubs/Nebraska. You can get to it and apply to be part of our hub, and then you can find those. So we're just getting started with implementing this hub and building the resources within here. So this is really on the ground level. And I know that perhaps some of you are working on this OER thought, maybe Go Open or Future Ready or some of the initiatives that your schools are working on. And we want to make sure that you understand and know that this hub is available to you for your teachers to use also. So I would suggest reaching out to your ESU colleagues and get some instruction and direction on how to get started, how to use that, and so forth. But what this really allows you to do is, you'll see this is a combination of different things. So we have our Nebraska hub, you'll see that in the top left corner. And you can also find other hubs. So as I said, that we had been looking into other states and what the content that they have. So you can do that as well, look at other state hubs. You can add your own resource. You see that kind of in the upper right-hand corner. So anyone can, once they have an account, can add a resource. It may not be in our hub, but they could add or create a resource of their own. And then towards the bottom, you see in the center, you see the groups. So we do have a number of groups already created in our Nebraska hub. And this is where that work would start. So the PE teachers have met. Some PE teachers have met and have vetted some of the resources in actually in OER Commons and aligned them to our standards and determined using a rubric, an evaluation type rubric, determined what we would want to have included in our Nebraska hub, and then it was endorsed by our NDE. And by doing that, then it becomes available in these collections. So OER Commons and our Nebraska hub is I don't want to say complicated, but it has different levels of resources. And so if something is in our collection, and this is our ultimate goal, is to have these highly vetted, high quality resources to be available in Nebraska's hub collection. And so that's what we're working on. And then again, as I talked about, you can do work. So you can do some of your collaboration work in these groups. And we would suspect that some districts perhaps might even want a group of their own, or some ESUs might develop a group and then organize that for their school districts. But again, if you're interested or you're working on any of these OER types of resources at your school district, I would suggest reaching out to your ESU contacts and get started that way. But anyway, the 5 R's, we used to have, the 3 R's, but now it's really the 5 R's of a Creative Commons. So you can create your own resource and retain that. Obviously, you can reuse somebody else's, you can revise, and I think that's the awesome piece of this whole thing is that I know that Bobby Toohey makes great resources, so I want to go pull his work and then add my customization to that. Or I can pull both of your types of resources and bring them in together. So, and then always thinking about how to make this better and sharing it. And I think that is where our world is that it's not our tunnel vision and just us working alone. We really have to have that mindset about how do we do this better together.
Yeah, absolutely. A couple more quick points on that. Number one, I think one of the ways that I've had a few boards that have asked questions and administrators ask questions about it is, well, so you're saying that this could ultimately be a cost savings mechanism to our district. I think absolutely. And that's a value neutral assessment on my part. You do whatever you want as a board. But I remember listening to Dr. Ken Fossen talking a couple of years ago at one of our conferences about the Millard math curriculum that they developed and being willing to share that on OER Commons. And so this is something that's happening. There are states out there that have enormous, in some cases even statutorily required repositories. So to the extent that we're sort of on what I view as at least a little bit of the cutting edge of making this a statewide effort and having the right people involved, we got a bit of a field of dreams scenario. I think if we build it, they will come type of thing. Because there are other states that are fully launched years into this and have really well populated collections and things. So we're working with the Department of Education to make sure that the vetting process doesn't run afoul of any of the other copyright interests. For example, if you've purchased Saxon Math, Saxon Math isn't going to want you to share that stuff on OER Commons. That's not going to be permissible. So there are some considerations about knowing that what you've populated in and of itself is something that you should even be putting into the collection. That's just one example of sort of thinking through the back end part of this. But I mean, ultimately, I think it's something to be excited about, and it's something that is happening out there across the country. So,
and in terms of that cost savings, yes, the resource itself might be cost, but I think that would allow for you to then provide financial resources for your teachers to really start to develop that content also. So currently we're spending all this money on our textbooks and so forth, and we don't have enough time to give to our teachers. So if we can flip that, I think that's what a number of schools and states are doing or considering is how do we flip that and give those opportunities for our teachers to then vet or to develop or create the content.
Yeah, and so I'm sure Beth would be happy to take any questions that you've got on that. Our plan also is to continue working with other groups out there. We'll work with the guys from the Perry firm, with NDE, and make sure that there are no other issues that we ought to address. But if you've got any questions from the legal side or from the practical side, let us know.
Yeah, very good.
Cool. Well, thank you, Beth.
Yeah.
We'll keep trucking along here. So thanks to Beth for helping us troubleshoot our technology issues, being the communicator on our messages. And with that, we'll keep trucking along here to make sure we get done. We are somehow magically pretty much on track. So the answer to back to the hypo is, and the reason we put OER Commons where we put it, is I think how this teacher went about doing that answers the legal question, right? And so the question of, did that teacher technically violate the school district's copyright interest by selling it on teacher pay teacher is probably yes, unless there was some sort of written authorization and it went to something like OER Commons and not teachers pay teachers. So there's a lot of stuff in there really, but the concept of agency law, did they do it for our purposes? The employer answers the initial question. What can be done with it after that is completely up to the board. So that's where the policy side of it, thinking about how that sort of thing is developed in your district is important. So yeah, I think it's a problem unless there's an authorization in writing, such as by a policy or contract.
Last thing we'll say on this, our firm also represents ESUCC, and so we have policies for school districts and for ESUs that we will push out to subscribers probably yet this week. And everybody else, we're going to do a blog post that explains this. We were holding off to do that until after this webinar because we wanted Beth to have a chance to show you some of the awesome that is OER Commons. And so I guess our goal is that if you're not the superintendent and you're listening to this webinar, that you go back and share with your upline administrators why it is so important that you get a policy in place that allows you to share your stuff on OER Commons, because you can see this is going to be to the benefit of the entire education community.
All right.
Yeah, continue to text questions. We're
So
gonna keep
I actually
going.
creeped on the back channel messages while Beth was talking because I just totally took over her computer. So thank you all for sticking with us. And as you have questions, or if you have questions come up, text them. And we'll just keep trucking along. 10:48. Yeah, I think we do the next section, then we'll take a bathroom break.
Very good. Music in the classroom. This is actually one of the topics that I think led to this entire presentation. We've gotten many calls that resulted in very unpopular answers.
Well, and the NSAA put out some guidance on this, like don't violate copyright laws. If you remember, what was that, last year maybe? At some point anyway. So it became a buzz in the education community.
All right, so we're going to start off with 4 hypotheticals about music in the classroom. First two teachers asked to play music in the class. First one, English teacher wants to play classical music from Pandora while the students write and take tests. She has studies that show that listening to classical music while working improves performance. What if she uses the radio? Does that make a difference? We then have the shop teacher just wants to play some rock and roll in the background from Pandora while the students work on projects. What if she uses the radio? Does that change anything? Our third one, we've got the school's therapy dog ate the sheet music. The band teacher needs to make 100 copies before the concert tonight. Can she make those copies? And our final one, nobody likes to warm up or watch players without warm-up music, so Bobby fires up and blares some Barbra Streisand, his favorite artist. Music over
They're not funny.
I spent an embarrassing amount of time last night trying to make Bobby's Bitmoji dance. I will tell you, I failed, but just imagine that in your brains and it will entertain you even more.
But they're playing that over the sound system during warm-ups. Does the school need a license for that? There's not too many ways to sexy this up. These are the guidelines from Circular 21 that comes directly from the Copyright Office. Permissible uses, you can make emergency copies to replace purchased copies. That would be one. A second one is academic purposes other than performance. You can make a single or multiple copy of the excerpts of the work. The third one is printed copies, which have been purchased, may be edited or simplified with some certain restrictions on there. The fourth one is a single copy of recordings of performance by students can be made for evaluation or rehearsal purposes and may be retained by the school or individual teacher. And the final one is a single copy of sound recordings may be made by an educational institution or an individual teacher for the purpose of constructing oral exercises or examination. So those are your 5 permissible uses under the music in the classroom. The prohibitions, copying to create or replace or substitute. Again, the anthologies, compilations, or collective works, they don't like that. The consumable exception, again, you can't make copies of workbooks, exercises, things of that nature. Copying for performance purposes other than we just talked about. Copying for the purpose of substituting for the purchase of music. Again, don't steal is basically what that is, except as we said in the emergency exception. And then copying always has to include the copyright notice on the created materials.
Ms. Hazy.
So we did, this will not surprise you. We divvied these slides up last night, and you see I don't have anything in front of me because I just don't go that way. And the guys had to over under on how often I said, "Is this you? Is this me?"
Instead, she just didn't do that. She's done 4 of mine and 3 of Steve's. So
Have I really?
yes. Steve and I have our own side action going on this, by the way.
That's horrible. So if you want to play music in the classroom, basically the older the better. When we say the classics, we don't mean the Stones. We mean like Mozart. And the more highbrow, the better, because again, the older the work is, the more likely it is it's in the public domain or it's not protected by the Copyright Act. Here's the bottom line. Most performances of copyrighted songs require a license. You just, playing Taylor Swift because we need to shake it off and shake our booty. That's a copyright violation, pure and simple. You can rearrange, edit, or simplify a copyrighted work if you're a music teacher, and the riff on the Stones songs is too hard. You can rearrange it. But you can't alter the fundamental character of the composition. And you can make a single recording of a kid practicing like your district music contest or just to show how awesome our music students are, but you can't sell that or stream it for public entertainment. It has to be for educational or archival purposes. Is this me?
Yep.
Okay. I want you make a little check mark by these next 3 slides because we're going to circle back to this when we get to the speech team. But in terms of music in the classroom, this is a executive for legal affairs with one of the publishing companies saying, performing a live song to demonstrate technique is okay, playing a CD is okay, all of that would fall under the educational face-to-face exception. So the face-to-face exception says the performance has to be initiated by instructors or pupils. So this won't cover your, the traveling Shakespeare companies. They have to have their own way to be not violating the Copyright Act. It has to occur within the context of face-to-face teaching activities. So the kids singing their district music contest piece for the teacher to see if it's good enough to compete in, that's covered by this. And when they go to district music and they go in that little classroom and perform to get a 1 or a 2 or a 3, that would be covered by the face-to-face exception. You see the weird geographic requirement in the 3rd bullet point under the performance must be. It has to be in a classroom or a library or a studio. It literally cannot be in the auditorium, can't be at the nursing home or any of the other places because it has to be in a place devoted to instruction. Once you get into the face-to-face exception, then there's no restrictions on the type or amount of copyrighted work that can be performed. So if you're going to sing Taylor Swift at district music, you're cool, as long as you aren't going to perform it at the end of district music for parents' night. But the actual district music contest, you can use copyrighted music. Can't be used for somebody brought in from the outside, cannot be given for the recreation or entertainment of any part of the audience. So I'm nervous about parents' night. Can't be part of profit making, and it can't be in an auditorium or school assembly because then they say, look, now you're doing a class play, so you should have to pay the author. That's not an individual doing this just for an instructional purpose. So that face-to-face exception is helpful as long as you keep in your brain that it's basically a kid learning how to perform and doing it in a small setting like a classroom or the library or the music room, something like that. Still me?
Still you.
A student performing at a school concert, so this is your elementary music contest, or a music concert now, parents coming in to see the kids perform. You can't charge admission unless you've paid the performance copyright fee for that music. And the copyright owner, if they hear about it, can actually write to you and say, don't perform. This has happened actually a few times in New York public schools where like the long-haired music composer is actually living in the same town where the performance is going to take place. They can send you a notice saying, we don't want you to perform it. I've never had this happen in Nebraska because, Imagine Dragons doesn't hear about Lexington doing their songs at their concert. So that's the one way that we can get out from under the school concert exception. And the last bullet point, this only applies to music, not dramatic works. Again, this is not a way for you to get around paying the public performance license for your one-act play or your fall play. It only applies to music performances for concerts. Again, the choir concert in the spring, the elementary Christmas concert, that kind of stuff. So here's the question. Does it fall under one of the exemptions? If it's in the public domain, you don't have to worry about copyright at all, but 9 times out of 10, somebody more recently has rearranged that music, so be aware of that. Does it fall under fair use? Does it fall under performance at a concert? You can't charge admission, remember that. Or if you charge admission, it can be only for an educational, charitable, or for charitable purposes. So a musical play requires the public performance license. So again, I know those get expensive, but there's really no way around it. It does not exempt, that does not apply to the band playing at the pep band. So you're gonna have to have a public performance license for your pep band music. And this is a really good resource that from the Music Educators Association that has good, like how to do all this stuff without violating copyright. The Music Educators Association is a really good resource all the way around. We actually don't have problems with music teachers. It's sports and sometimes drama teachers because they don't get as good a training on dance teams. Yeah, actual straight music education, they tend to do a pretty good job.
And you've been buying boxes of the sheet music for a long time, right? That's sort of, I view it sort of like textbooks.
Yeah.
That's your music classroom textbook to some extent. So you've always typically purchased any of the rights that you would need anyway. So yeah, but these same concepts, trying to apply them to other areas is a little
It gets a little tricky.
tricky. Yeah. Okay. So here's a question. May a music teacher put on a recital of songs performed by the school choir and charge an admission fee? May a parent video the holiday concert for personal use? May the school record a student performance and post it on the school's website? And so 2 teachers asked to play music in the classroom. We're going back now to our, I think that might have been duplicate. Anyway, sorry. 2 teachers asked to play music in the classroom. The English teacher wants to play music from Pandora. She absolutely has studies, research, which will say that it will improve student test scores and all that sort of stuff. That's great. I think that research does actually exist. We think you still need a license. I don't think it's fair use because she's not teaching how Mozart scores a requiem. She's playing Mozart's requiem while the kids are taking a test. So I don't think you've got a fair use in that context.
Now remember, I said the older the better and the more highbrow the better. So you're saying to yourself, well, wait, she should be able to play Mozart on Pandora because that's old. But the problem is it's probably like the New York Philharmonic performing Mozart. And so somebody rescored Mozart's, there's no harpsichord in this or whatever, there's no cloggers. I don't know what all's in there. But most of the time, somebody recently has put their hands on that music to have some kind of derivative work. So just because it's old and highbrow doesn't mean that we're automatically safe because somebody has probably updated it for this performance.
Right. In other words, what Steve was talking about when we first started, the public domain website, that might well apply to the very original work, right? I mean, that original Mozart work obviously is out of any sort of copyright protection. But when you are getting it through Pandora, it is probably somebody else performing it, which means they now have they probably paid, if they needed to, performance license, your teacher didn't. So when it comes through Pandora, Apple Music, Amazon Music, one of those, you got a whole new set of issues.
Now we're getting text messages. Thank you, you're making me happy. We'll answer all these in a chunk.
Yeah,
Keep going.
so not least of which, I think one of your problems is the extent to which their terms of service for things like Pandora, Apple Music restrict performance, right? So I know there are classroom options available out there, which is good, right? If you get Pandora for classroom, that's great because Pandora, right? The reason you're paying for it is because they've done the vetting work on that to make sure you're not using it in an unlawful way. If the teacher just loads up his or her own personal Pandora, if you Google Pandora in the classroom, the first website that pops isn't stop, make sure you're not violating copyright. It's here are the 16 best playlists to use if you're a music teacher, if you're somebody who wants to play Pandora in the classroom. So the universe out there, if you're just leaving your teachers to wander through it, isn't real clear. It makes it look like, oh yeah, you can totally do this.
If you are going to not prohibit teachers from playing Pandora in the classroom, the 3rd bullet point, is it a public performance? I think we need to do as much as we can to get within that exception. So I would say that the teacher should only play it for the students in his or her classroom. The teacher should probably close the door, which hopefully they're doing it anyway. The teacher should talk about how much they love these children and whatever. Because we want to make it as much like you had a party at your house and people came over and you happened to have some background music on. We want to make the classroom look as much like that as possible so that we can at least argue if you get sued that it's not a public performance.
And that it's not played every day, right? And that it's true. If your research is indicating to play it for tests and you're playing it every day, we've lost any real argument that this is anything other than for personal enjoyment,
right?
Which wouldn't be permissible. That'd be like blaring it, in the warm-ups at a basketball. Okay, so we're coming to that. So what if she uses the radio? Does that make it any better?
It actually makes it worse because the radio station has paid for the public performance of the songs, but you have not paid the radio station for the broadcasting of its on-air talent. So now you've got 2 potential copyright violations: the music license holder, because you didn't get permission from them, and from the radio station.
So how about the shop teacher? Again, wrong. And I think you lose any sort of educational argument in the case of the shop teacher just wanting to have music on in the background. And again, you're still getting colder if she's using the radio. How about the school's therapy dog eating the sheet music? We think that one comes out differently because of the circular, right? There's nothing in that circular that talks about playing Pandora. There might have been if the circular wasn't developed in 1976. But now we do know for sure that making things like emergency copies is permissible. That's, again, because of the guidance from that circular, not because it's just objectively clear in the law that you can do that. So,
And notice that it doesn't matter if it's an emergency and it falls under the circular, the quantity doesn't matter. A lot of times educators would shy away from 100 copies because they'd be like, I don't know, that feels wrong somehow. If you are under one of the exceptions, the volume doesn't matter.
right. Yeah, for whatever reason, making 2 copies feels less violative than 100. But if it's a violation, it's a violation unless you're falling under one of the exceptions. So how about the warm-up music? We think this is a public performance. It's the reason the NSAA has either intentionally or unintentionally put all of you on notice that you shouldn't be doing that.
Yeah,
We've
so the
said it for a long
NSAA
time.
notice was basically like, hey, if you're gonna play warm-up music, check and make sure you're doing it right. But they didn't tell you how to do it right, you notice, because it's really hard to find a way to make sure that this is okay.
Yeah, there isn't a great answer. You need a license. I think that's the bottom line. Now, the variety of responses we've gotten from these music company copyright enforcers has been across the board. We've had 2, maybe 3 entities who have actually gotten some sort of contract license, ranging all the way from, no, you absolutely can't play our music. In between has been things like, oh, you're a public school. We don't enforce against public schools. Of course, none of which is put in writing. So it is entirely possible that if every one of you calls these different music representative companies and asks, I need to get a license for basketball warm-ups, will you provide that to me? You're probably all going to get somewhat different answers.
We literally had one school get a license, and then another one of our clients called the same company and said, hey, we want a license, and they said, we don't do that. We sent them a copy of the license that their company had sent out to the other school, and they're like, yeah, we don't know anything about that. It's extraordinarily frustrating.
Yeah, the representatives must work on some sort of commission basis because you got different answers from different people. So the frustrating part, and why we, to be perfectly honest, hate doing copyright presentations for a lot of reasons, is because we're very solution oriented, and there just isn't a good one in this context.
We do have one solution,
This
which
is
you won't
Karen's
love,
solution.
but your local DJ DJs get a license for public performances of the music that they play. So if you're really committed to having warm-up music and you're willing to pay, or you got a local DJ that'll cut you a deal, a local DJ that is playing using their license should be able to play, because they only have access to certain libraries, so they're gonna know what they can and can't play. That would be one way to get this music out. In fact, we have one client that for their senior graduation video, they have the pictures up on the screen, and they hire a DJ to play the music that goes with it, so that they are not violating copyright law when they have that senior music video.
Yeah, we have the same concerns for if you're striving your games, for example, and that's picking up the background music. So for a lot of reasons, there are a lot of different complicating factors which aren't getting easier. And we hope maybe someday the music industry will just throw a blanket exception out there for schools playing for warm-up music, but that hasn't happened.
There is actually a law pending in the federal Congress to kind of give some more guidance about music and copyright. I have not dug into it entirely, although it would include some kind of more universality in the licensing. The problem is I don't think anything's going to happen in Washington, so I don't want to invest a ton of time in learning it, but we do have that on our radar and we're tracking it. If it passes, we'll let you know.
So we put these up here for literally every copyright presentation we do. I honestly don't know how helpful it is, but one of the difficult parts is, let's say that your basketball team puts together a playlist that has Taylor Swift and Imagine Dragons and somebody else. It's entirely possible you're actually going to need 3 separate licenses from 3 separate companies, because there's not like one place that you go to find all licensed music. So this adds to the complexity of it. Again, we apologize for not having great answers, but
We're trying.
you roll the dice in a lot of other areas. So if you're like, Bobby, I'm going to keep playing Pandora before the basketball game, that's up to you and the board. If they ever find out about it, I guess
We'll fight like hell to defend you.
We'll fight, but I don't know that there's any other great answer out there.
Okay, so this has generated lots of text messages. Thank you. That helps me know that you're out there still listening with us. So thank you very much. So the question about the school concert exception or the public performance exception, what about a board member who thinks we should put a donation bucket out at our concerts? That does not automatically make you charging admission, but just make damn sure, because when I've done a couple of these where it's like donation, there's an aggressive patron standing at the door saying, hey, it's a $10 donation. And then they shove the bucket in your face and you feel like a jerk if you don't put $10 in the bucket. So if it's just sitting there passively, I do not think that constitutes charging admission. But if you've got somebody like functionally suggesting that you should pay, that's when you lose that exemption. So I'm okay if the bucket just sits there and you let the Holy Spirit guide their hearts, but you can't give the Spirit a shove, if you know what I'm saying. Somebody asked, what about Strive? Strive in general, I'm cool with. Striving the music concert, one of us did some research on that. Wasn't that you, Steve-O?
I don't believe so, but.
I have at various times, and to be perfectly honest, as a lawyer, we all struggle with this. The A+ law school answer is you would absolutely not strive your music concert unless you know that you've got any number of the potentially, half a dozen licenses, which might be required for you to do so, because you're blasting that out on the internet. It's no different than if you record it and post it on YouTube, right? YouTube will send you a takedown every time unless you can certify to them that you've got the licenses required to send it out to the universe. The live nature of it, the concert exemption, the face-to-face stuff, that really doesn't apply when you're taking it and broadcasting it out to the world. You become a TV broadcaster.
Our best bet is to argue the school concert exception. That's where we would go if one of you got a takedown notice because you strived your concert. So at a minimum, please don't record it and archive it on your Strive account and let people come back, because then the more permanent it is, the worse. But the problem is that school concert exception is specifically key to it occurring in the physical location of the school. And once we're striving it, we're not in the school anymore. Now, Grandma and Grandpa love it. Like my mom has really big mobility issues. The ability to listen to stuff on Strive is huge to her. I get it. So it's a calculated risk, but I think we would lose that.
The other thing that I think you should think about that's a lot of things in one sentence. You ought to think about looking at the music when you purchase it. Yeah. So if you're going to purchase a certain song to be played at the spring concert or to be sung at the spring concert, ask that person from whom you're buying it if you are able to broadcast it on your school's YouTube channel or Strive or whatever it might be, because you can always buy the appropriate licenses, and with the representation from the person selling it to you, that's probably okay.
So, for example, all of the cartoons we have here, we can buy them to use in slides, but we also can buy an additional amount of license to post them on social media and on websites. So we pay that bump up. So there may be some additional cost to including the rights to broadcast the concert, but it may be worth it because I know that Strive is part of like an important part of some of your cultures. Anything else on Strive? Somebody just texted OMG.
It happens out there.
Yeah.
I mean, we know what happens.
Yeah.
And the Taylor and the work those guys are doing is really cool. We love it. We support it 100%. It's hard for us to give the A+ law school exam answer, which doesn't tell you shut it down, which is why we don't like to do that. But yeah, it's a calculated risk.
What about radio stations playing through business sound systems? I had this case. This was one of my first jobs as a lawyer. The Wilbur Hospital got a takedown notice because they were playing, I think it was KTAP radio, the radio station I worked at in high school, was playing the radio over the sound system. So the senior partner that gave me the assignment was like, this is BS. You send him a letter, tell him to go to hell. And I did the research and had to go back and tell the client and the senior partner that you can't just play the radio station over the sound system. Now, the radio station has a broadcast license, so the radio can play no problem. But when you amplify it back through your own sound systems, you are now violating the copyright law. You'll notice when you go into big chain stores like Forever 21, the music they're playing over their speakers is canned. They are not playing the radio for this very reason, because your license, the radio's license, does not include rebroadcasting in other businesses.
Bars, same sort of thing. That's why they pay so much money for jukeboxes and all that.
We have ASCAP. Does that help protect playing music for sports? Absolutely, as long as you are only playing ASCAP licensed music. But that's fantastic. And that's the way to play it. If you can get a license from one of these publishers, that's great. How do we get around music in the classroom? How can I legally play music while my kids work? Yes. We feel your pain. In fact, we hashed it out again yesterday as we were talking about what to say here. These guys say don't do it.
We say get the right
right.
license. There are places that you can go to get classroom. Now, might not be exactly what you want, but I think there are ways that you can do it. I don't know that you're going to be able to turn on your favorite Pandora station and play it in the background.
So, and then the tail end of this is, do I need to purchase a Pandora account? You need to purchase a Pandora Classroom account, which is one step up from an individual account. If you are bound and determined, you've heard us and you say, okay, I don't care, I'm still playing music, then do as much as you can to make your classroom when you're playing the music like your home. So close the door, don't do it all the time, have it keyed to specific activities. But unless you have a Pandora Classroom account, we can't guarantee that you're gonna be cool. We'll defend you hard. Can students listen to their own Pandora accounts during study hall with earbuds? Yes, they can, because now that's not a public performance.
Personal enjoyment.
And that license for an individual, you know, they individually have the license to listen to it, even if they've got the free Pandora account, because they have permission from Pandora.
Yeah, go read the Pandora Terms of Service, and you'll be surprised at how many things they put in there about these exact questions.
So this is why I love superintendents. Now I have a follow-up question on Stride. Can striving the concert be homework? Can it be like the media class's job is to strive the concert? You're getting closer. The problem is most of like homework, that would be the face-to-face exception. And remember, that has to happen on school grounds in a classroom or not an auditorium. But you're getting closer.
And to be clear, we've got no problem with a basketball game broadcast that doesn't have any of the background music that you're maybe unlawfully playing for warm-ups, but has your students calling the
Talking.
play-by-play
Now you're good.
and recording your game, right? FERPA allows that because you're not disclosing it. It's student records to the extent that it is, you can disclose it. It's when you're combining it with the music that you have to pay to broadcast out. Otherwise, you'd put radio stations out of existence if all you had to do was say, oh, we got kids doing it, right?
Yeah.
That's just not how it works.
Is there a Pandora account for athletic events?
I don't know. Not that I'm aware of.
We have research to find this Pandora Classroom license level, so we'll do some digging. I think we would have found it if it existed, but we'll look. My fear is that there's not, because what they're going to be worried about is that like everything that the university plays at Husker football games, they've paid for, and they paid out the nose for it. And I'm fearful that they're not going to have like an athletic event license because they're not going to want to let Notre Dame and Nebraska get over on them. But we'll look. We'll look, and if we find the answer, we'll blast it out.
They overpaid for the last couple Ton of Walk songs, in my opinion, but that's neither here nor there.
All of you that gave me crap about my predictions.
Moving along.
We
Now,
do have a comment on the chat. ASCAP and CESAC,
CSAC, yeah.
CSAC, do not sell licenses to high schools. They called them out last week after receiving the NSAA memo. So
ASCAP, but they lied to you because one of your peers has a license from ASCAP.
They just
talked. So yes, I agree that when you call, sometimes they say, oh no, we don't. First they say we don't sell licenses to high schools, and then they say we don't enforce against high schools, which is a lie because sometimes they do sell licenses and sometimes they do enforce.
Yes.
Now the fact that you made that phone call is money. Because remember, go back to the very beginning when we were talking about damages. Your damages are significantly reduced and sometimes zeroed out if you had good reason to believe that you had permission. So document the Billy heck out of that phone call. And if they come sniffing around, you've got that to use. But I cannot say you are golden once they tell you that they won't give you a license.
Right.
Because remember, this is about control, not about money.
Yes. And you might have to, depending on, so the links that we had up there were to the repositories of those different places. So if you've called ASCAP and if you've called CSAC and they've said the same thing, oh, don't worry, we don't enforce against public entities. Believe me, we've heard it all.
Yeah.
Unless they're willing to send you that in writing, I just don't believe it. But to the extent that you're playing music, make sure it's from their libraries, right? Don't then go to the BMI library and play
there's about
some Elton John. right?
Four
Don't do that.
major publishers that hold the rights to popular music, and it all is littered all back and forth. And the superintendent that is still committed to striving. What about Spotify? Spotify, Pandora, Apple Music, they're all the same, honey. Good try.
That's why you have to
That's
listen to
why we love you.
commercials for the free version, right? I mean, they've got to pay the bills to those artists, and they want you to do the same.
This is my favorite. I love this part of doing this because I love your text. Okay, so
De minimis.
what's 10?
Oh,
we
you
have
want to take a quick break?
Quick bathroom break?
Yeah, we're actually on track. We probably only have about 35, 40 minutes left, so.
So let's take a quick 10-minute break. You can check your email to the extent you aren't doing it behind our back, and you can go down the hall with me 5-minute break, says Bobby. So
Then we'll be done a little early, I think.
all right, 5-minute break. We'll be right back.
All right. We're back. We're going to talk a little bit about de minimis use. This is something that's even less than fair use. We'll start off with a hypo. The kids in journalism want to start a podcast. As part of that, they want to have intro and outro music, which is Mirrors by Justin Timberlake. Can they? Which I listened to this morning for the very first time, even though you said I had heard it before.
I made
never-
fun of
You're
Steve.
welcome, Steve.
I
Never heard
said
this.
Steve has no idea what the song
I
is.
told Steve, Mirrors by Justin Timberlake would be part of my intro outro music if I had a podcast.
If we have extra time at
Fantastic
the
song.
end, I'll show you how I can dance just like Justin Timberlake.
We're not gonna have time.
So we have a couple of cases, one that came out each way, but what they do here, this is another area, again, no bright line rule, so it's kind of frustrating. And so when you call, it might be the answer is it depends, and maybe. But in Sandoval, this was the case that involved the movie Seven. And what we had was some photographs that were in the background. And as it turns out, the only person who absolutely would have known that those were his photographs was the person who took them. And he sued, of course, because that's what we do. And so the court said, well, those photos appeared fleetingly. They were obscured by people and objects. They were out of focus. They're very blurry. And they're virtually unidentifiable except to this guy. And so they said, no, that's clearly a de minimis use, and we're not going to hold that there was a copyright violation for that. It was simply a background blurry item. Then we have the Ringgold case, which was the old TV show Rock, which I had to go look up because I don't think I remember that one. But with this one, we had a poster in the background for 27 seconds, but it was clearly visible. It was recognizable, and there was a lot of detail in that picture so everybody could tell what it was. And they said that is a copyright violation. So you can see there, again, not a bright line rule, but sometimes we can even get away with a so-called de minimis provision. So practical advice, obviously less is more, and less comes from the heart of the work. The one we were kicking around yesterday was Can't Get No Satisfaction. You take that one riff out of there, that's the song. Everybody knows what that is. So you could have, just with that little riff, that could be a copyright violation if you take that little part. Difficult to have a de minimis use of an image Googled and then used on a website. Let's face it, it's everywhere.
Well, so I always struggle with how to articulate what I'm presenting on copyright, the difference between de minimis and fair use, because the amount and substantiality of the use is part of the fair use argument. I think here's the difference. You have a student who puts a picture on a part of your website that he created in web design class, and it's the basketball going through the hoop. That's there forever, every day for people to find. That same student puts that picture one time in the slideshow at graduation. It scrolls through, it's there for 3 seconds as a cover photo. In the case of the graduation, we can argue both fair use and de minimis, or at least we try. But in the case where it's on your website, we can't argue de minimis use because it's not possible, right? We're going to have to
entire
find
picture.
some fair use. It's the whole picture, it's there all the time. So de minimis, to the extent Steve said is less than fair use, is true. And that doesn't mean that you should just start continually using a smaller sample, right?
Yes.
Because it's not necessarily what it's talking about. It's talking about it's truly so small that we don't even have to get to fair use.
And the cases for the various ways that you can have a copyright violation, they're all over the place. There is no standard answer that we can give you on these. So if you're looking at using one of these and want to know if it's de minimis, you're going to have to check with each use on each of those items. Right? All right, so they want to use the Mirrors by Justin Timberlake. Can they? We probably need more information. How much are they using? How much are they sampling? Or, from the ones I saw this morning, one was 4.5 minutes long. There's original. There's a remix that's, well, maybe 10.5 minutes long that I listened to. But anyway.
Old man
Um,
listening to Justin Timberlake at 6 a.m. This
I wish
is
I could have seen
terrifying.
that.
And so you need to know more. Oh, you guys are killing me. So it depends upon the amount used, obviously.
Yes.
Keep in mind, if it's posted, they will be on the internet searchable. They will find you.
That's
I mean,
where people get tagged.
And that's what, you saw that little basketball picture. Are you kidding? They have these bots. They search for you. They find you. They will tag you. And you've got some decent companies that actually just want what they're entitled to. But you've got these other squatters that'll come after you for thousands of dollars for taking some stupid little picture. So you just have to be really careful.
I will be surprised if we have questions on de minimis use, although we put a space in here because that just seemed to, this fits. Basically, we wanted to include de minimis because we don't want you to, like it's out there on the internet, we don't want you to rely on it too much. Basically, it's don't do this at home, call your lawyer first. So, no more questions. Nobody's trying to use de minimis for Pandora or Strive, so off we go.
Movies in the classroom.
Right. right, another fun one. All right, we're going to start off with some movie hypos. Do you need a license when? The history teacher shows Schindler's List as part of a unit on World War II. How about if the fifth grade teacher shows Despicable Me for raising the most money for a fundraiser? Kind of a reward type question. The PTO shows Beauty and the Beast on movie night. So are you going to need a license in each of those instances? We also have TV in the classroom, which is a little bit different. Do you need a license when? So a teacher records an episode of Friends and shows it to the class during free time. A history teacher records an episode of ESPN's 30 for 30 on racial integration of sports and shows it during history class on integration. A science teacher shows an episode of 60 Minutes on Hurricane Florence that he recorded a couple of days ago. And so those might be a little different. Movie Licensing USA. This is where pretty much everybody goes to get your license. They are the exclusive provider of public performance licenses for K-12 schools, with one exception, 20th Century Fox. They don't have 20th Century Fox. That is through Criterion Pictures. But everybody else, you have to go to Movie Licensing. You can get an individual license for one single event. They're relatively cheap. You can get a blanket license for a year. Those run anywhere from $300, I think they're up to $700. Depends on your student enrollment. That's how they base that.
And it also depends on if you're covering affiliated groups like your PTO or not.
And so you can get those online. You can get them by phone, but that's the place to start if you're looking at a movie, unless, like I said, it's 20th Century Fox. TV in the classroom. This came up in 1979, and it makes a lot of sense when you think about it. VCRs came in vogue in the mid-70s. And so there wasn't a lot of guidance as to what can we do as educators with these programs. There's a lot of stuff we could tape and show in class. So Mr. Kastenmeier was a congressman at the time, and he created a committee. And so they put together this document to give us guidance on and we still use it, on what you can show in the classroom. So it can only be programs that are broadcast for reception by the general public without charge. So anything on HBO, ESPN, Disney, those are out. We can't have any fun there. It must be shown in a classroom setting, similar to what Karen was talking about earlier. It has to be shown during the first 10 consecutive school days after it was recorded. You can retain it for 45 days to evaluate whether you're going to continue to use it for the curriculum. If you are going to, you have to go obtain permission. Otherwise, you have to destroy that record.
Which you're not going to be able to do with Netflix or Hulu or
Amazon Prime.
yeah. So it gets a little more interesting. Yeah. Anyway.
You don't have to play the entire show, but again, they don't want you making anthologies or compilations. Schools are expected to establish appropriate control procedures to maintain the integrity of these guidelines. There wasn't a lot of guidance on what this meant, but I found it interesting. You weren't required, you were expected. And so there really is no requirement on that, but they do want you to have some procedures, some policy in place to address how that's going to work. Again, as Karen had said earlier, PBS has a lot of exceptions. They want you to use this for educational purposes. So what they suggest you do is contact a local PBS station, and they'll give you guidance on what their specific rules are.
I had a question from an administrator yesterday who asked, "Oh, Bobby, my Movie USA, Movie Licensing USA license is due. Do I really need to get that? I mean, can I just wait to buy it until they sue me?" No, that's the point of having a license that's in place before you use it. So I said to the administrator, well, what are movies used for? I mean, do you have like a list of everybody who shows movies and whether they're arguably educational or just for reward? Well, no. How would I know that? Ask your staff, right? I think that's what expected to establish control procedures means, not just here, but throughout the copyright stuff when it talks about reasonable diligence to make sure you are fitting within one of the exceptions. So have a list. Anybody that shows a movie or wants to have a permission requirement, and just have them send it to you so that you can analyze this.
Or if you buy, I think Movie Licensing USA is actually one of the best deals out there. I love talking about movies because I actually have answers. When I was PTO president, I actually got the licenses for movie night. I mean, it was like $25 to $50. It was worth it. And the entire system is set up to make it so that the license is cheaper than the settlement of the claim. So this superintendent, you are gambling, but they're going to try to make sure that if you get caught, they're going to clip you for enough that that is not worth it. And real quick on Disney, particularly very aggressive in enforcing their copyrights. They have caught PTOs violating the copyright laws by parents posting on their personal Facebook pages that they went to movie night for the PTO and that they saw, whatever, give me a Disney movie, get little
Beauty and the Beast.
Beauty and the Beast. And they literally have then tagged the school for the copyright violation because some parent just posted on their personal Facebook page that they went and saw the movie at PG movie night. So it's just, they'll get you. The interwebs will get you every time. Well, most of the time.
All right, so back to our hypotheticals. Do you need a license when the history teacher shows Schindler's List? No. I mean, we've got an educational exception. Clearly, they're teaching it as part of the class. How about when the 5th grade teacher shows Despicable Me for being the leading fundraiser? Yeah, you do need that. I mean, obviously, that one's just for entertainment. And how about the PTO showing Beauty and the Beast on movie night? Karen's giving that one away as
Sorry.
PTO president. Yes, of course you need a license for that.
The middle one about showing Despicable Me for raising the most money, sometimes educators would think that they agree that that's a copyright violation. But if we show Despicable Me because everybody scored at grade level on their NISA test, does that get us to the educational exception? And I think the answer is no, because you're not teaching about the movie, you're using it as a reward, even if it's a reward for an academic activity.
And similarly with the TV in the classroom, the episode of Friends, that's a reward. So obviously you're going to need a license for that. The history teacher who's teaching the racial integration, you're not going to need a license for that. That's the teaching exception. And how about a science teacher shows episode of 60 Minutes on Hurricane Florence? Because it's within that first 10 days, no, you're not going to need a license.
Now, history teacher, if the 30 for 30 was not within the time frame with the different TV rules,
You still would have to be within that time frame.
Yeah.
So you'd have to get through the 10 days as well.
Or hope that you can still articulate fair use outside of those CASA-Meyer guidelines. Sure.
so that's why that's in there, because that one's kind of tricky.
Yeah. And I think that actually highlights the difficulty of the fact that you can get that stuff so quickly on demand, right? You just log into your Watch ESPN account, and you can probably pull up that 30 for 30. So the 10-day stuff is harder to enforce with the advent of you're not actually carrying it in cassette tape.
Questions on movies and TV. What about reading a book and then watching the full-length movie?
Is there an educational purpose or is it a reward?
If it,
Good job, everybody. Gone with the Wind is super long. We're now going to take a full week of class periods to try to watch that baby. It's my wife's favorite movie, so I've done it way too many times. That is it a reward? Are we analyzing differences? Are we talking about how this character is portrayed in the book relative to the film? I think if you can tie an educational purpose to it, you're probably okay.
if you read the book, take the test, and then watch the movie,
Reward.
it's a reward. If you read the book, watch the movie, and then you test, and it's designed to have the kids understand like what a play looks like when it's actually acted out, like stage directions, for example. You read stage directions, but look, it's not, they don't say stage right in the movie, then I think you can argue it's for an educational purpose. But if it's for a reward, as the follow-up text says, I think you're gonna need a license. And again, that's why I think for once we have a solution. That's why that Movie License USA building-wide license it could be money well spent.
Yeah, and I think it's become such an industry standard that y'all know it exists.
Yeah.
That's one of the things I'm worried about is showing a video for a reward without going to Movie License or Centurion is going to get you in trouble. Because if they ask all your neighbors, it's like, well, yeah, of course we all do it. So you know now probably that it's an intentional violation.
Okay, that's it for the questions. Thank you. Keep the text coming.
Karen, as our resident speech geek, is up next.
Now, this actually blew my mind. So those of you that are out here listening, you'll have to tell us whose side you're on. Bobby and Steve act like speech and forensics is like the most bizarre activity that they don't understand ever. And you know, I'm a recovering speech coach. That's what I did when I was a teacher. And so when I talked to the speech coaches for the NSAA this summer, I put together this little section on how copyright and speech intersects, and Bobby and Steve were like, we never thought about this. So with that said, we're gonna do a hypothetical speech team, and we have a poetry student who wants to do a dramatic reading of many of Taylor
When
Swift's
it's you,
songs.
so of course it's dramatic.
And those of you that do need to be told how poetry works in real life, lots of times kids will use cuttings of a bunch of different poems to like put together a thematic word program. So we're doing all of T Swift's stuff. It is true that Taylor Swift is one of the most aggressive copyright enforcers in the music industry today. So it is not inconceivable that Taylor Swift would have a problem with this. So here's the question. If I want to do a dramatic reading for my poetry contest piece, can I do that at district speech if we know that Taylor Swift probably would not grant me a license and would have a problem for it? Second question, can I do my poetry reading at parents' night? Since the dramatic reading of Shake, Shake, Shake would make all the parents thrilled, can I be the feature performer? How about when we send the kids out to the nursing homes to do nice things for the area elderly people? Can I go read about the fella over there with the hella good hair? Can I do that in the nursing home? And the answer to each one of these, I think, is dependent on different analysis. So remember when I said to put a little check mark by the classroom use for music? I actually was going to copy and paste those slides again in here, but I didn't want to junk up the deck. So if you're talking about whether or not a student can use poetry, music lyrics, published work in actual speech contests, that face-to-face exception is going to cover you for actual speech contests. Remember, that has to be the teacher and the student have to be in the same room. That's what happens in a speech contest. Has to be in a classroom or a library or something like that. That's exactly where these events happen. And it has to be for an educational purpose, for making the kid better or helping the kid to understand the nature of the performed work. So the face-to-face exception is going to cover you for all of your speech contests by and large, okay? The reason I have the public performance license up here is, what about when you do finals for entertainment speaking in the auditorium because everybody wants to go hear the funny speeches? Or if you have like the most popular OID, which is like when they read a play, sometimes we do finals for that in the auditorium because it's just easier to accommodate a bigger group in the auditorium. You're gonna have to think about, is this now a public performance? If it's a musical work, you have to obtain a license. Good news, the reading Taylor Swift's poetry or lyrics is technically not a musical work because we're just doing the lyrics, so that's the words, it's poetry. It's probably not a dramatic work because we're not actually performing it as it was designed to be performed. It's not like The Sound of Music when they're singing and dancing across the stage. It is probably a non-musical dramatic work, which means if we were gonna perform it in the way it was intended, we'd have to pay a royalty fee. But if we're relying on the face-to-face exception for a student just performing, we're okay. Which means, this slide means it's a different answer if finals are held in the library versus if finals are held in the auditorium. And this is why I think all of your speech contests probably should be in classrooms, because then I think we can cling to that face-to-face exception. So remember, student performances at a school concert would be exempt as long as no money changes hands and the copyright owner can prohibit if they hear about it. So if Taylor hears about my awesome poetry cutting and we're gonna do finals of state and it's gonna be in the UNK auditorium, if she hears about it, she can make it so that I can't perform in the auditorium, and then we would have to be have them around in the classroom. So it's weird to me, but the geographic location of the speech contest matters a lot for the copyright analysis. Sometimes we have speech teachers that want to record student performances. I used to do that all the time when I coached. Number one, check the license and see if it flatly prohibits a recording. Sometimes we're cutting from a play that the school has bought the license to, and the play license will include public performance but will limit recordings because they have a problem with that. That brings us a problem with Strive, again, for live streaming speech contests. Now, teachers can do a single recording of a musical performance, but that's not gonna get us the solution for speech because it's not a musical performance. That requires another license if you're going to distribute it. And for a non-dramatic musical work, again, if you're going to perform it and record it for anything other than just for the kid to use personally to get better, you're going to have to pay the royalty fee. So recording these performances creates a whole nother level of difficulty is the point. So forensics competitions, which these two didn't know what forensics was. Again, I want you to text me and tell me how you're judging them. Forensics.
I don't know.
Because you like judged my entire professional life before I went to law school.
I'm just judging how important it still is to you.
It's I'm taking a deep cleansing breath. So forensics would include both speech and debate. That's why that probably qualifies under the face-to-face exception. But I'm concerned if we strive or stream kids performing their cuttings, we have a whole nother problem with copyright. And that is true of all of your interpretive, so poetry, OID, humorous prose, dramatic prose, all of that, we have problems. But now what about your platform events? Persuasion, informative, entertainment. Any kid that's using a visual aid that they've copied out of a book, we're gonna have to think about what the copyright implications are of that. But a kid doing a speech that he or she wrote themselves without a visual aid, extemp, impromptu, we're probably cool because now it's all the student's own work, assuming we haven't plagiarized the speech. Parent night is another problem because again, we're not now in the face-to-face exception. We're not in a classroom. We're not having the kid just do it for their own benefit. It's like for the parents to be happy. I think we're probably okay as long as we don't charge admission to parent night, but that is a risk. It's a calculated risk to have students performing in the auditorium for parent night. What if mom videos the kid reading the cutting and then puts it on her Facebook page? Or we had a kid probably 5 years ago who was graduating from high school and he did his serious prose in church as like part of a sermon. And I think that's probably copyright violative because that's not the face-to-face exception. It's not for educational purposes. Then it becomes more of a performance. So getting back to T-Swizzle and whether or not I can do poetry, 100% I think I can use Taylor Swift's lyrics for district speech because we're in that face-to-face exception as long as active coaching and teaching is occurring and the rounds are in classrooms, we're good to go. Can we use Swift's lyrics for parent night? We're getting closer. I'm not sure. You for sure cannot charge admission. We probably then would be under the school concert exception, not the face-to-face exception, but please don't record it because I'm worried that that takes us out of the school concert exception. And this is terrible. Can we go to the nursing home? The answer is just no, because we're not in the face-to-face exception and we're not in the school concert exception because we're not doing this on school grounds. I'm worried about this for your show choir going to the mall. A lot of times like local businesses or the Rotary or the Lions have kids come in and do either an interp event or sing show choir songs at their someplace other than the school. I mean, that's, again, it's a calculated risk, but understand you are outside of some of the protections that we have for educational purposes when you physically leave school premises and do stuff off grounds. And that seems stupid, but there you have it. Okay,
Questions about that?
couple of text messages. Now, we're reading a book, we want to watch the full-length movie, that's a reward. What if you show about 5 to 7 minutes of the movie in conjunction with reading the book? Is that a copyright violation?
It's not a reward, or it is a reward?
It doesn't say. 5 to 7 minutes in conjunction with the book. Let's say it's not a reward.
Yeah, so I think that's fine. If it's like how whatever Rhett Butler is portrayed in the book versus in the video,
Yeah.
and then comparing those two, I think that'd be totally fine.
I agree. And actually, in terms of like pedagogical purpose, that's a really great lesson.
It's better than probably reading it than watching it whole, actually.
Yeah,
right?
because
I mean,
your
there's
strongest
more-
teachers aren't showing movies over the course of 4 days and then not doing any teaching. Just saying. Just putting that out there. We have an all about me wall. Every kid puts a collage together about the things that interest them and then hangs it on the wall. Is that a violation?
I think it is, unless they're getting a grade for it. Well, let's
I
say
think it's for an educational purpose, isn't it? If it's for like,
senior spotlight.
well, what is the kid putting up on the wall?
Right, and that's gonna
Family
be the question.
pictures.
Family pictures, fine, but the full quote from some John Gordon book? Maybe.
It's close. It's close. I am so happy. I don't know who you are, but I love you. What about using that picture of Taylor Swift? Did you get permission from her directly? We
No.
did. Well, not from her directly. That image is used pursuant to our Shutterstock subscription, and it does. Carly, you're my favorite today. So yeah, we did not talk to Taylor herself, although she and I talk every so often. But we did. That picture is downloaded from. We have a Shutterstock subscription, so we pay to have access to these pictures. And so both Justin Timberlake and Taylor are pursuant to that Shutterstock subscription. So And I don't think, I'd have to go back and look. It's not super, like, again, everything we have in this slide deck, everything we use over the years that you see us doing continuing ed, we have paid for all of it. It's not cheap per se, but it's not so hideously expensive it's beyond any school's reach. Truly, it's not. I should go look. We paid $40 a cartoon for the non-subscription ones. I think we paid $250 a year for the Andertoons. I mean, that's not that much money.
Okay, so in your slides, some of you have the stuff about the images on schools' websites and those things. We covered that earlier because we thought it fit a little better up there. So if you get the updated slides from the website, they'll be in a different order. So that's why when we get to student tests and records here, that has skipped some if your ESU printed these all off for you. So Karen is going to cover these quickly, and then we're going to breeze through the recommendations and be done hopefully in about 5-10 minutes.
So this is actually an issue in special ed all the time where a parent says they want to see the student's test protocols to know if you say my kid is learning disabled, I want to see the question and the answer that my kid gave instead of just taking your word for it. And it's an interesting issue. This is a lawsuit where a parent demanded under the California student record laws, the tests themselves, the protocols, and the answer sheet. And basically the parent wanted to go back through and regrade the test. The school then went to court and said, hey, judge, don't make us turn this stuff over because we think we would be violating the copyright law. And the court said, in this specific case, we were trying to educate the parent to help the parent understand that their kid actually was learning disabled, that could fall under the fair use exception. The parent didn't want to get the test protocol so that they could sell them. They wanted it for an independent education evaluation. The court said normally test creation is strongly protected, but in this case, the court said the school could give the parents only as much as necessary to understand that the student truly was learning disabled. I will tell you that there's a crap ton of special ed cases that have gone the other way. Most hearing officers will not order schools to release test protocols that are copyrighted. My best advice is if you have a parent that demands the testing protocols, I would sit down with them and talk through the fact that we have copyright issues. I'd get your lawyer involved sooner rather than later because we want to make sure, because this is one of those that you're going to get sued if you get the wrong answer, no matter what you do, right? Giving it to the parent, you get sued by the testing company. Not giving it to the parent, you get sued by the Department of Ed or you get a complaint from the parent. So there are a couple of cases that allow the testing protocols to be given up, but for the most part, most of the courts have said, or hearing officers have said, you don't have to give the entire protocol. Here they said this is just one time, it wouldn't have a widespread effect on the market, but if that's true, it's going to be true, across. If everybody has to do it, then it will have an effect on the market. This is interesting because we had a personnel hearing this summer about what the protocols are about the NISA tests. If a teacher has students copy down the questions for NISA, not only is that an ethical violation, but technically that's a copyright violation because the Department of Education in Nebraska owns the copyright to all those questions. And this is exactly that case. This is a teacher that worked for Chicago that thought standardized tests were stupid. And so in his little underground newspaper, which was called Substance, he published the questions that were on the Chicago standardized tests, not really so much to make money, but to say, look how dumb standardized testing is. The court said, in general, we want to encourage people to have a robust discussion of political issues and whether or not standardized testing is good. But dude, if you publish the test, you're going to destroy the entire value of these limited access norm standardized tests. It would completely destroy the value to Chicago if we allowed you to do that. And so in this case, they said, Mr. Teacher, you can't publish these tests, not because it's illegitimate for you to have a political opposition to standardized testing, but because you would take away all the benefit that Chicago, they'd spent millions of dollars getting these tests to a place where they were norm referenced. We're not going to take away the entire value of the testing system. So fair use doesn't apply in this case because it would undermine the entire value of the test. This is just a funny little video about fair use, and it's like, it's a fairy tale characters trying to use fair use. It shows you how stupid lawyers are because we were entertained by it, so we thought we would share it with you. I don't know if you'll be as entertained as we were, but we were. So there you go.
Okay, the question we had come in for the collage where students are adding their own pictures and things. In some cases, they're using photos, for example, photos of Husker games or the Pittsburgh Steelers or the Kansas City Chiefs, so that other students will understand, oh, we both like the Kansas City Chiefs, which I think you can try to weave some educational purposes into that, right? Kids to learn more about each other, but I'm still a little bit worried about the extent to which if a kid is Googling that off the internet and taking the best picture they find, it's probably owned by some news organization who paid that photographer, or by that photographer, or by that team. So it's not ideal, but if they can find the grainy cell phone picture that some random fan took, that's better than the clearly professional picture that somebody from a news organization took. But I think if you can tie some sort of reason for it, like for example, kids are going to look at it and know each other better, then we've got an argument.
I also probably would encourage Creative Commons to use Creative Commons here. Now, Creative Commons is not a solution, because it's not a one-size-fits-all solution, because if I rip somebody's photograph off and upload it to Creative Commons, that doesn't mean that the person that took the original photograph doesn't have any enforcement ability. But remember, the more good faith you're engaged in, the lower the damages, or we can even zero out damages. So if we're using Creative Commons and we're relying on a representation that this is copyright free and that the person that took the picture has said you can use it, then I think you have a much better argument for reasonableness. Then also that can be an educational purpose, because we're teaching kids about respecting copyright. And so that gets us another defense. So I would try to use either OER or Creative Commons, something that we would at least have a representation from somebody that this is in the public domain.
So real quickly, there are multiple types of license, right? When you're talking about a radio broadcast, you've got 4, 5, 6 different types of licenses that could be available. So think of a graduation ceremony. If you've got a band performance, you've got mechanical, arrangement, master, performance. If you set, Green Day, Good Riddance to your slideshow at graduation, you've got then the reproduction of that work, distribution, broadcasting, possibly performance if the choir's going to sing it. And if you're selling copies of the videos that you took at the band performance, you're posting them on your Stride, you've got even more licenses. So again, I think the thing to do if you're worried about this stuff is ask the person that you're getting the music from what it actually covers, because if that's not clear to you, you could have paid for a license that doesn't actually cover what you need. I think that you should do a copyright audit and inventory at some point. So whether this is as part of your PLN or something, but essentially have a spreadsheet or some document that has 3 columns. Ask every teacher to put the materials that they use in class, which they did not create. Then have a little check mark for if you know that the school bought it from Houghton Mifflin, that's great. We probably got a license for it. If not, the 3rd column should be the copyright exception. So Gone with the Wind showed as a reward versus Gone with the Wind showed as part of the academic experience. Your staff would then know, or you as the building administrator would have to think, okay, which of these is it? And it at least give you a way to, again, hit that reasonable belief that we weren't violating copyright laws.
Hold on just one second. We should create that form and share it.
Karen's going to create that form and share it.
I'll create a Google Doc and share it with the world. I'll put the link on the website, because it would be helpful to have it for us too.
And again, that would be, then it's something for you to give to your staff, but either
And
way.
then I
think
will
it's-
let you use it under a license, and then I will not claim copyright for it.
And again, be thinking about, we didn't talk specifically about dance team, but you got the same problems there, right? It's from the teacher's iTunes account, and they play that music. I mean, that's still limited by all the other things we talked about. So again, I would include then your sponsors in this. That's the point.
Yes.
Provide copies of that circular if you haven't. That's at a minimum the classroom use stuff, and I think it's easy to do, and it contains a lot of the stuff Steve talked about for movies and music as well. You've got the circular. Distribute it. It outlines the maximums, talks about things that you can do, gives at least some objectivity to it. And with that, despite our technical difficulties, we are 1 minute early. So any final questions?
Yeah, any final questions? I'm checking texts. Thanks guys for sticking with. We did record this, so if you can get through the first, couple of crashes, it would be available if you want to review chunks of this with your staff. And then we are going to send out a questionnaire to ask about how you went. You'll notice we did this different. We sat this time, and I'm real curious. We truly crave your feedback on this, so let us know what your thoughts are, if this format works for you, and what we can do to make it better.